Hi, folks. Welcome. We'll get started in just a minute. Hi, folks. Welcome to Representing Children and Families in Immigration Matters, presented by the American Bar Association's Commission on Immigration and the ABA's Children's Immigration Law Academy. The Commission on Immigration directs the ABA's efforts to ensure fair treatment and full due process for immigrants, asylum seekers, and refugees within the United States. The Commission houses several projects. First, the South Texas Pro Bono Asylum Representation Project, or PROBAR. PROBAR is a national effort to provide pro bono legal services to asylum seekers detained in South Texas by the U.S. government. The project recruits, trains, and coordinates the activities of volunteer attorneys, law students, and legal assistants. Second, the Immigration Justice Project, or IJP. IJP of San Diego seeks to promote due process and access to justice for indigent immigrants and asylum seekers through the provision of high-quality pro bono legal services for individuals appearing before the San Diego Immigration Court and appeals as needed. Third, the Children's Immigration Law Academy, which we will talk about more in just a moment. Fourth, Federal Free Legal Answers. In Free Legal Answers, qualified users may post legal questions and authorized volunteer attorneys may provide legal advice for immigration issues, including notario fraud. Fifth, the Detention and Legal Orientation Program Information Line. The Detention and LOP Information Line provides cutting-edge, individualized assistance to detainees held by Immigration and Customs Enforcement, or ICE. Sixth, Know Your Rights. To help ensure America's commitment to justice for all, the ABA's Commission on Immigration has produced and updated a Know Your Rights educational video for the more than 400,000 people held in immigration detention facilities across the country each year. The Children's Immigration Law Academy, or CILA. CILA is located in Houston, Texas. CILA is an expert legal resource center created by the ABA's Commission on Immigration. CILA builds capacity for those working to advance the rights of children seeking protection through trainings, resources, technical assistance, and collaboration. CILA first opened its doors in late 2015 in response to the thousands of children from Central America who surged across our southern border fleeing prolific violence and abuse in their home countries, and who sought humanitarian protections offered under U.S. law. CILA stepped in with a vision to empower advocates with the tools needed to guide children through complex legal territory. And we are very lucky to have CILA be presenting this with us today. And CILA also has a fantastic and comprehensive pro bono guide for working with children and youth in immigration cases that they first released in August 2020 and updated in September 2021. And there's a link to that in the Dropbox. The ABA's Commission on Immigration hosts two online platforms that connect pro bono attorneys with volunteer opportunities. First, Pro Bono Matters for Children Facing Deportation is an online platform that connects pro bono attorneys to nationwide volunteer opportunities to support children facing deportation. Thousands of young people in immigration court have no attorney at their side, and representation makes a significant difference in the lives of children facing deportation. Many children have legal relief available that could offer them protection and more security in the United States, and the only thing missing is knowledge and guidance to navigating the system. Second, Pro Bono Matters for Families Facing Deportation is an online platform that connects pro bono attorneys with nationwide volunteer opportunities to help families that are placed on the family group dedicated docket in the 11 designated cities. The dedicated docket is an expedited docket for certain families in removal proceedings who have been placed in the alternatives to detention. The goal of the dedicated docket is to adjudicate the cases within 300 days of the first master calendar hearing, meaning that pro bono representation is especially crucial in helping the families access counsel and protect their due process rights. and we will chat about more ways to get involved later this afternoon. And for today, this afternoon, we will be joined by wonderful panelists who are experts in the field, spanning across multiple federal circuit jurisdictions. The first training session is Nuts and Bolts, Common Forms of Immigration Legal Relief, that will run from 12:10 p.m. to 1:10 p.m. Central Time, and then we will have a 10-minute break. The second training session involves Practice Before USCIS and Removal Proceedings 101. That'll run from 1:20 p.m. to 2:20 p.m. Central Time, followed by a 15-minute break. And the third training will cover interviewing skills when working with children and families in immigration cases. And that will run from 2:35 p.m. to 3:35 p.m., followed by a 20-minute presentation on how to get involved. And we will save the last 5 minutes for closing remarks. We hope you will be able to attend all of the training sessions today, but you are able to leave and come back if you are unable to participate in all of the sessions this afternoon. Additionally, the sessions are being recorded and will be available after today's presentation. You all should have received a Dropbox link, and that has great materials, including the CELA's Pro Bono Guide, case theory and evidence matrices, information on ethics and trauma-informed representation. Just as a housekeeping note, please post your questions in the Q&A box throughout the webinar in lieu of using the chat box or the raise hand feature. And some information on continuing legal education credit. This training is approved by the State Bar of Texas for up to 3 participatory hours of CLE credit, including 0.25 hours of ethics credit. The recording can be viewed for CLE credit until February 28th, 2023. And upon completion of the webinar, please complete the CLE credit survey and provide us with your Texas bar number so that CELA can request credit for you. And for individuals seeking CLE credit outside of the state of Texas, the content of this program does not meet requirements for CLE accreditation. However, CELA is able to provide letters of attendance so that you can request CLE credit from your state bar. Through the CLE credit survey, you can provide the information we need to create and email your letter of attendance. And first up is Nuts and Bolts, Common Forms of Immigration Relief, but we have a few minutes.
Emily, I think we need you to stop sharing your screen so that the panelists can share theirs. Great. And even though I think we're maybe a few minutes ahead of schedule, I think we can go ahead and jump in and get started since we have a lot of info to cover today.
Okay, I will go ahead and introduce our wonderful panelists. Today we are joined by Stacey Hammond. She is the senior immigration attorney of the Immigrant Rights Defense Center in Latino Memphis. She has been an attorney with Latino Memphis since September 2015, and Stacey oversees the program's representation of clients before the Memphis Immigration Court and before the United States Citizenship and Immigration Services, or USCIS. She represents clients in cases for asylum, special immigrant juvenile status, relative petitions, adjustments of status, and cancellation of removal, as well as a variety of other cases. Prior to joining Latino Memphis, Stacey served as the attorney advisor at the Memphis Immigration Court for 2 years. She is a graduate of Penn State's Dickinson School of Law and the George Washington University. She was admitted to the State Bar of Pennsylvania in 2012. And she spoke on a panel entitled Digital Tools for Immigrant Integration at the Unidos US Annual Conference in 2018. And also joining us today, we have Shakira Maria Rodriguez Olveres, and she is a senior staff attorney at the South Texas Pro Bono Asylum Representation Project, or ProBar, in the Children's Project. Shakira graduated from Pontifical Catholic University in Ponce, Puerto Rico in May 2010, and graduated from Emory University School of Law in Atlanta, Georgia in May 2013 with an LLM in transactional law. In Puerto Rico, Shakira worked in several areas of law, such as criminal law, family law, and civil law. And in May 2019, Shakira began working at ProBar as a staff attorney representing unaccompanied children in the removal proceedings with USCIS. And in August 2021, Shakira was promoted to senior staff attorney. Welcome to our panel.
Okay, thank you for the introduction. We are going to start with our part of the webinar. We are going to start with our objectives for today. Stacy is going to help me with the slides. We are going to learn the basic elements of asylum and specific considerations related to unaccompanied children. We are going to learn eligibility requirements and procedures for SIJ applications. We are going to learn basic concepts of other humanitarian forms of relief, such as TPS, T visas, U visas, and VAWA. We are going to start now with asylum. So,
sorry, I don't know why this is working so weird, but we'll get it.
So we're going to start with asylum and the definition of asylum. As soon as we have this.
I'm gonna stop share and then reshare. Give me just 1 second.
Thank you, Stacy. Okay, there we go. Asylum is an humanitarian protection for a person who is unable or unwilling to return to their home country or avail themselves of the country's protection because they have suffered either past persecution or they have a well-founded fear of persecution on account of race, religion, nationality, member in a particular social group, or for their political opinion. And persecution.
I don't know. I'm not even touching anything.
Okay, persecution can consist on the infliction of of harm or suffering by a government or persons a government is unwilling or is unable to control, includes but is not limited to extreme physical violence, threats to life or freedom, or harm that causes permanent injuries, may be physical, sexual, emotional, or psychological, and can also be cumulative harm. Okay, past person.
I am so sorry. I do not know what's happening.
Past persecution. Okay, there's a comment from Emily. Okay, so past persecution established, there's a presumption of a well-founded fear of future persecution, and then the burden of proof shift to the government. So the government can review the presumption by showing that the internal relocation is both safe and reasonable. Relocation is presumed unreasonable if the persecutor is a state actor. They must consider the age, familiar ties, mental health, medical condition, language, race, ethnicity, gender.
Sorry, give me just 1 second. Okay, fingers crossed. Oh, we even practiced this before.
Yeah, we are.
Okay, fingers crossed, fingers crossed.
Hope that works. Okay, so go again. So if past persecution, it's proof, then it can give rise to a presumption of well-founded fear of future persecution. The burden of proof is shifted to the government, and the government or DHS can review the presumption by showing that internal relocation is both safe and reasonable. Relocation is presumed unreasonable if the prosecutor is a state actor. They must consider the age, familiar ties, mental health, medical condition, language, race, ethnicity, gender issues, means of survival. Generally, it's not reasonable to expect a child to relocate. And they can also argue change circumstances such that that fear no longer exists. In humanitarian asylum, past persecution alone can establish eligibility if the harm was severe and atrocious, or there's a reasonable possibility of other serious harm. Okay, the well-founded fear of persecution. The legal standard is a reasonable possibility of persecution. That means that a reasonable person in applicant circumstances will fear persecution. And there's a 1 in 10 chance of persecution. There are two ways of establishing a well-founded fear. There's an evidentiary presumption arising from past persecution and objective facts establishing risk of future persecution. We have a 4-point test. First, if the applicant possesses or is believed to possess a characteristic the prosecutor seeks to overcome. The prosecutor is aware or could be aware of the applicant characteristic. The persecutor has the capability to persecute the applicant, and the persecutor has the inclination to persecute the applicant. Okay, we need to establish nexus. And that is the link between the persecution suffered or feared and at least one of the 5 enumerated protected grounds. The person were or will be targeted by the persecutor on account of a protected ground. The protected ground must be at least one central reason for the persecution and can be established through the submission of direct or circumstantial evidence. Okay, we have here the 5 protected grounds: race, religion, nationality, political opinion, and membership of a particular social group. A particular social group must have 3 elements. First, the group must be composed of members who share a common immutable characteristic. The BIA has described a common immutable characteristic as one that the members of the group either cannot change or should not be required to change because it is fundamental to their individual identities or consciences. Second, the group must be defined with particularity. The BIA observed that particularity refers to discrete and well-defined boundaries to provide a clear benchmark for determining who falls within the group. Third, the group must be socially distinct. And social distinction means that the group is perceived or recognized as a group by society, and a social group cannot be defined exclusively by the fact that the members have been subjected to harm. Okay, the proof. The burden of proof is on the applicant. The standard is preponderance of evidence. The testimony may be enough if it's credible, if it's persuasive, and if it refers to specific facts. The standard for children is that adjudicators should account for age, developmental stage, and other factors in assessing a child's testimony. Understand that children may be unaware of specific details or circumstances that led to their departure, have limited knowledge of conditions in their home countries, as well as their own vulnerability. The safe third country exception does not apply to unaccompanied children, and also the 1 year filing deadline does not apply to unaccompanied children. The initial jurisdiction in affirmative asylum is on the Asylum Office of USCIS, regardless of age or reunification status, unless affirmative steps to terminate the unaccompanied children designation has been taken. If USCIS denies the application, the case is referred to the court. Okay, the benefits. Well, it would be eligible to work in the United States, may request derivative asylum status for the spouse or children who were listed on the asylum application, can adjust status to lawful permanent resident, and they are subject to special rules for traveling outside the United States. And we have, this is like a summary for your reference of the other two legal relief. You can also apply with the same form, the I-589. You can also apply for withholding and protection under the Convention Against Torture. And there we go with Stacy with our next topic.
Okay, so I am going to talk about special immigrant juvenile status, which is a common form of relief for children. So the eligibility for special immigrant juvenile status, you have to be under 21. You see there's a little asterisk mark. We'll talk a little bit later about the juvenile court order that you need to get for special immigrant juvenile status, and that might have a different date. But if you're under 21, you're eligible for a special immigrant juvenile status. You have to remain unmarried throughout the whole process. So from the time that you file all the way up until you have your green card approved. So I joke with my clients that every single time I talk to them, from the second that we start their case until I hand them their green card, I'm going to remind them not to get married, because if you get married, the whole process stops and there's nothing that you can do to kind of to fix that. You have to be in the United States to apply for special immigrant juvenile status. If someone's still in home country, they are not eligible until they arrive to the United States. And then most importantly, you have to be able to show that the child has been abused, abandoned, or neglected by one or both of their parents. This is determined on the state law in which the child lives and the definitions of those terms under state law. Special immigrant juvenile status does not require that the child be unaccompanied. And so even if a child came to the United States with a parent, with one of their parents, and the other parent abused, abandoned, or neglected, they can still be eligible. It does not require the child to have entered without inspection. If they came on a visa, they can still apply for SIJ. And it does not require that the child still be in OR custody or be released from custody or anything like that. It applies to all kids. So there's a 3-step process for special immigrant juvenile status that we'll go through. So the first step is obtaining a predicate order from a juvenile court, then filing the I360 petition for special immigrant juvenile status, and eventually, if the I360 is approved, you're eligible to adjust your status to that of a lawful permanent resident. So first we'll talk about the juvenile court order. So this must be obtained before the minor ages out of juvenile court jurisdiction. So this is where I referred to earlier, applying for SIJ, you can do that up until you turn 21. However, you have to obtain this juvenile court order before the age that is required by the state that the child lives in, right? So I'm in Tennessee. We have our minors age out at the age of 18. But if you look just to the south of me in Mississippi, the age out is before 21, right? So there's some circumstances in which a 19-year-old or a 20-year-old could still obtain the juvenile court order that's required for special immigrant juvenile status if they live in Mississippi, for example. So you'll see across the country, the vast majority of them, of the states, have the age out at age 18, but some of them do have 19 or 21. And so you'll have to look at the specific state law for whatever state that you are in. So the juvenile court order has to be obtained from a, quote, juvenile court. So this, again, depends on the state law for whatever state that you're in. So the juvenile court is defined as any court that has jurisdiction under state law to make judicial determinations about the dependency and or custody and care of juveniles. So for example, here in Tennessee, in Memphis, we go to the probate court, right? And we get guardianships for our clients. But in other states, you might need to seek a different process, and that will just depend on your actual state law. So within the order that the juvenile court judge issues, not only do they have to, make the normal, guardianship or custody findings, but there's also special immigrant juvenile specific findings that must be included in order to qualify for SIJ. So first, that you are dependent on the court, that you cannot be reunited with one or both of your parents because of the abuse, abandonment, or neglect, or similar basis under state law, right? So the state law might have some other wording that they use, but it, essentially means abuse, abandonment, or neglect. And then finally, the judge has to find that it's not in your best interest, in the child's best interest, to return to the country of nationality or the last habitual residence of you or your parents, right? So in most cases, this is just home country, that it's not in their best interest to return to home country. I know, so one question that I get a lot is, who can be the guardian or have custody or whomever? Again, depends on state law. So here in Memphis, we can get guardians for the guardians that are undocumented that can be guardians, right? So immigration status doesn't matter, that kind of thing. But again, it depends on the judge, it depends on the state, that kind of thing. So if you're new to this area, I would highly suggest reaching out to a local practitioner that's done these kind of things before for tips and tricks specific to your area. So now we've gotten the juvenile court order. The next step then is to file the I360 petition. So the petition, the I360, is used for a lot of different types of applications. If you look, I think, to page 2 of the application, there's a bunch of different categories of cases that it's used for. So this petition, there are a number of pages within the petition that don't actually apply to special immigrant juvenile status, right? So you can just skip over them. But you'll file this petition along with your G28 entry of appearance, the predicate order, the order that you got from the juvenile court, and a copy of the child's birth certificate with translation if it's not in English. This application is always filed with USCIS. They always have jurisdiction over these applications. And this application must be filed prior to the 21st birthday. You can't file on the child's 21st birthday. You'll have to file it at least the day before the 21st birthday. And this applies regardless of what state you're in and the age of majority in that state, right? So my kids in Tennessee, my kids in Mississippi, even though the states have different age out rules, we always have to file before the 21st birthday. And so especially if you're in a state that does have jurisdiction in the juvenile court up to 21, remember you have to get the order obtained and the 360 filed before the child turns 21. Otherwise, they lose access to special immigrant juvenile status. Right now, because a lot of these kids, especially if they're unaccompanied minors, they are in immigration court. One thing that I'll point out is that when you get this 360 approved, often OCC or OPLA will agree to dismiss the proceedings against the child to allow them to wait for the priority date to become current so they can apply for residency. And so definitely, I mean, personal opinion is that it's always better to not be in court. And so if you can get that kid out of court, you save time of you and your kid having to go to court, and also, any complications from, the judge might throw at you in the process. Okay, so now we've gotten the juvenile court order, we've gotten the I360 approved. Now we want to apply for permanent residency for the child. So the timing of the application for adjustment of status is dependent on the visa bulletin. The visa bulletin is a whole nother can of worms. So I'm sure there are trainings out there on specifically to the visa bulletin, but I included here the March of 2020 visa bulletin specifically for SIJ, right? So these are the final action dates. You'll see that we're in the employment-based chart, which doesn't make sense, but it is what it is. And we're in the 4th category. And so there are some countries, China, El Salvador, Guatemala, Honduras, India, Mexico, the Philippines, that are broken out. And then everybody else that's not in one of those countries falls within the first column. So you'll see here, for example, if I have a client that has applied for a special immigrant juvenile status that's from Guatemala, I can't file an adjustment of status application until unless the special immigrant juvenile status petition was filed before May 1st of 2017. So for people that do have some experience with SIJ, you'll know that the March visa bulletin regressed 2 years from what February had been. And so, there's a lot of kids that are now waiting a long time to be able to apply for adjustment of status. And so hopefully by the new fiscal year in October, we'll go forward a little bit more. But as of right now, that's the date that we're looking for. I just saw a question from Rachel. No, it's not normal for the visa bulletin to regress 2 years. There had been some hints that it was coming. And so it didn't necessarily surprise people, at least me, but it was kind of a shock to know that it went back 2 years. And so we just have to keep waiting, as much as frustrating as that is. Okay, so adjustment of status, the jurisdiction of where you actually file the I-45 depends on whether the child is in court or outside of court. So if they're not in court, then you file the application with USCIS, just like you would for any other adjustment application. If they are in court, then we look at their NTA to determine whether they were classified as an arriving alien or not an arriving alien. If they were classified as an arriving alien on their NTA, then you file with USCIS. If they are not an arriving alien, then you file with EOIR. So again, I mentioned it before, you can try to get those EOIR proceedings dismissed, ask DHS to join a motion with you based on the prosecutorial discretion memo, and then allow your kid to go through the process with USCIS, right? In most cases, it's all done on paperwork. The National Benefit Center that handles these kind of cases is, fairly competent for USCIS standards. And so personally, I think that's a little bit easier of a process, right? And a lot of my clients, especially kid clients, are afraid to go to court. So if we can avoid court, that's also really great. Okay, and then as soon as somebody files for adjustment, remember that they are eligible for employment authorization. And so file for that employment authorization. Even if you have a 6-year-old, right, it's still a form of ID for them. They also can get a social security number with that work permit. And so it's, there's a lot of different benefits to it, but especially if you have, older teens that you're representing, they're likely to want to start working at some point or get a driver's license or that kind of thing. Okay, then my favorite practice pointer. Fee waivers are available for special immigrant juvenile status adjustment of status applications. I have a policy to not give the government more money than I have to. And a lot of because I work in a nonprofit, a lot of my clients are low income, and so I don't want them to spend money that they don't have to. So if you're filing your adjustment application with USCIS, there's an automatic fee waiver. So you file the I-912, the fee waiver application, with a copy of the 360 receipt or approval. There are instructions that specifically say the sections that you don't have to fill out on the fee waiver application. And so you don't have to prove income. You don't have to prove income of the child, of the guardian, anyone. You just show that they're filing for adjustment based on SIJ, and it's automatically waived. For EOIR, it's up to the immigration judge, right? So you file the fee waiver with the immigration judge. I have some judges here in Memphis that are like, okay, yep, there's SIJ, grant the fee waiver, right? I have another judge that requires us to provide proof of income for the entire household, right? So you just have to figure out what your specific judge wants. Okay, so then, so that's a special immigrant juvenile status, which is obviously limited to kids, right? So temporary protected status is obviously available to everyone, regardless of age. So temporary protected status is a temporary status, as it implies, that can be designated due to quote unquote temporary conditions in a country, right? So this could be an ongoing armed conflict. So there's a lot of talk or pressure on the current administration to do TPS for Ukraine, and because of what's happening in Ukraine right now. They can also designate TPS for environmental disasters. So some of the older TPS designations that still exist are because of hurricanes that happened, years ago that destroyed countries. If you think to the earthquake in Haiti, and the fact that country was, destroyed in that earthquake, TPS then was designated for that. Benefits of TPS, if you are granted TPS, you're not removable from the United States. You can obtain a work permit, and you can apply for advanced parole to be able to travel outside of the United States. So in order to be eligible for TPS, you have to be a national of the designated country. You have to file within the initial registration period. And then if the TPS is extended, you have to keep registering every time there's a re-registration period. You have to be continuously physical present since the date present in the United States since the date of designation. And you have to have continuously resided in the United States since the date that was specified in the TPS designation. And I'll kind of get to that a little bit. I have a TPS chart of all the countries with TPS right now. That kind of makes more sense. You're not eligible for TPS if you've been convicted of a felony or 2 or more misdemeanors. Certain admissibility applies to TPS, so you'll have to keep an eye out for that. Or if you're subject to mandatory bars that apply to asylum, such as persecution of others or terrorist activity. So here, this is the chart of all the countries that currently have TPS. So you'll see here the continuous residence date. Some of them are recent, right? So some of them are 2021, others, such as El Salvador, are 2001. So you have to have, and then you have the continuous residence and physical presence. You have to have been, El Salvador has a error here. This should be 2001. But you have to be physically in the United States since that date. So if, for example, you are from Nicaragua and you came to the United States in, say, 2005, you are not eligible for Nicaraguan TPS because you are not physically present in the United States when you were required to be there, right? So for a lot of the clients that you're likely going to be seeing, they're not going to be eligible for some of these TPSs, but there's some that are more recent. I just saw, so Venezuela, for example, last year was designated, and so we applied for a bunch of clients from Venezuela for that. I just added little asterisks here just yesterday. The government announced that they're going to be redesignating Sudan and South Sudan TPS, and so those dates have moved up now until 2022. Okay, so TPS. Every single person applying for TPS has to show eligibility for TPS on their own. There are no derivatives for TPS. So even if a parent has TPS just because a kid then comes into the country, they don't get TPS just because their parent has TPS. The child themselves have to show that they've been in the United States since the designation date that's in the TERP before. And then more recent updates, there is now no direct route to adjustment of status based on a grant of TPS. So there's a Supreme Court decision last year that said that TPS is not an admission for purposes of adjustment of status. There's a policy change that if you apply for advanced parole through your TPS status, that is simply travel authorization when you come back. That is not parole for purposes of AOS. But if somebody has TPS, but they have a different way to receive their adjustment of status, they can still go through that path. Okay, so I'll pass it back to Shakira to talk about other humanitarian forms of relief.
Okay. So we have the T non-immigrant status, we call it T visa, provides immigration protection to victims of human trafficking. In order to be eligible for a T visa, a victim must be a victim of severe form of trafficking in person, be physically present in the United States on account of the trafficking, comply with any reasonable request for assistance in the investigation or prosecution, or be under the age of 18 or unable to participate due to the trauma. And they must also suffer extreme hardship involving unusual and severe harm upon removal from the United States. Severe form of trafficking in person. There are two kinds. There's sex trafficking. Sex trafficking is a commercial act induced by force, fraud, or coercion, or in which the person induced to perform such act has not attained 18 years of age. We also have labor trafficking. Labor trafficking is the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, coercion, for the purposes of subjection to involuntary servitude, peonage, debt, bondage, and slavery. We also have the U non-immigrant status. We call it U visas. U visas provide immigration protection to victims of certain type of crimes, and we have a list here. I'm going to read a few: adoption, rape, sexual assault, incest, extortion, kidnapping. Okay. In order to be eligible for a U visa, a victim must be a victim of a qualifying criminal activity and suffer substantial physical or mental abuse as a result of the crime. Possess information about the qualifying criminal activity, or have been, or is being, or is likely to be helpful to the investigation and or prosecution of that qualifying criminal activity. They need to be a victim of a criminal activity that occurred in the United States or violated US law. Okay, it's a bona fide determination. USCIS attempt to address the massive U visa backlog and limitations of the 10,000 annual statutory cap applies to all pending I-918 petitions and all I-918 petitions filed on or after June 14, 2021, when this new process was announced. Bona fide means that the application was complete and properly filed, and a criminal background check does not raise any national security, public safety, or other concern. The applicant will be granted protection from deportation, called deferred action, and will be eligible for a work authorization document for 4 years, which can be renewed as necessary.
Okay, so then I'll switch back for a discussion about Violence Against Women Act, or VAWA. So this is specifically for victims of domestic violence. It's a self-petition, so that doesn't require the abuser to actually be a part of the process at all, and it allows the victim to submit their own application to USCIS. So you can apply if you are so it requires that the abuser be either a US citizen or a lawful resident. If your abuser is neither of those two, if your abuser is undocumented, for example, VAWA is not available to you, you would then have to go the U visa route and show everything for the U visa. So you can file if you've been abused by a USC or an LPR spouse, and then you can also include your children as derivative beneficiaries of your application. You can apply if if you're a child that's been abused by a US citizen or a lawful resident, by a parent. And then the spouse can also petition based on the spouse of the USC or LPR can apply based on abuse to their child by by their spouse. And then you can apply if you are a parent of a USC who has abused you. So notice there that it's only parents of US citizens, not LPRs. Even though the definition or the name of this is Violence Against Women Act, this applies equally to men and women. I've done multiple VAWA cases for men who are abused by their US citizen wife, right? Also remember same-sex couples, all of that doesn't matter, right? It applies to everybody as long as there's that legal relationship. So spouses that they're actually married. If you're not actually married, you would have to go to the U visa option, and then the children as well. So we'll go to the next. For spouses, again, you have to be legally married to a USC or an LPR, or you can file within 2 years of the divorce to that spouse. That 2-year deadline is a real deadline, right? You need to file before those 2 years are up. So definitely keep an eye on that if your client has been divorced. Then you have to show that you have to show the qualifying relationship, right? So the marriage certificate, the birth certificate that shows the parent or child is that relative to you. You have to have been subject to battery or extreme cruelty by the abuser. So there's a lot of misinformation out within the immigration world that just normal marital problems is enough. It's not enough. It has to be extreme cruelty, right? So it can't just be like, oh, my husband backtalked me one time or whatever, right? It has to, you have to be able to show that you were subject to this extreme cruelty. You have to show that you've resided with your abuser. VAWA also applies if the individual is still in that relationship. You don't have to show that they have broken up. If they're still living with their abuser, obviously have a conversation with your client about whether that is something that maybe you can help them get out of. But you do have to show that they've resided with the abuser. And then you also have to show that you're a person with good moral character, right? So if you have some criminal issues, you might need to assess that and determine whether you can meet that requirement for good moral character. So Shira, I'll just cover this real quick, but we've listed out all of the benefits of the various applications. And so, depending on, we might have a client that's eligible for more than one of these things, right? And so you kind of have to assess whether, which route that you want to go. Maybe you pursue more than one route. It just kind of depends on your individual situation. Okay, so we've listed our contact information here. I'm happy if anyone has any questions. I do a ton of special immigrant juvenile status, so I'm happy to answer questions in any way. We have some resources. I know that the hosts have also put together some resources, so happy to share those too. I think we have some questions. Let's see. Lenore Guzman asks, what if you get an approval notice and they're now over the age of 21? So I imagine that this is SIJ. So it doesn't actually matter. As long as the SIJ application was filed before they turned 21, that's what matters. So I have adjusted many clients that are older than 21, but they had filed the SIJ petition before they were 21. So that's a total non-issue.
There's another question. If a child has both asylum and SIJ, which relief will be more beneficial? So yeah, I don't know if you want to answer this. I can answer my opinion.
Yeah, give your opinion and I'll give mine if it's different.
It's something very personal because you know your clients and you need to know where exactly you're practicing. I practice in Texas. So our granting rate is very, very low. So what if I have a kid that has asylum and SIJ, I apply for both if I can, with USCIS, of course, not with the immigration court. So because SIJ applicants, they need to wait for their turn in the visa bulletin, like Stacy discussed. So right now, if you got an SIJ approved, you don't have any ID. But if you apply for asylum with USCIS, you can apply for an EID, and your client can have a work authorization for 2 years, especially if you are in one of the countries that are very behind, like Honduras and Guatemala. You want your clients to, have an ID, to have a work authorization, and if you just stay with SIJ, your client, only can wait. They can do anything else.
Yeah, I would just add on to that. If you also have to consider things like, if you adjust status based on special immigrant juvenile status, you can't then petition for your parents once you get your green card. Whereas with asylum, if you get a green card through asylum, you can file for your parents, right? In terms of travel, if you get your green card based on special immigrant juvenile status, you can still travel back to your home country, and which is really important for some of my clients, especially, kids that were raised by grandma or grandpa, right? They want to go travel back. But if you get asylum, you can't travel back to your home country, right? So there's a lot of different balancing acts, both before and after approval. So definitely weigh all of those. Let's see. Lenora asks, how do you get out of court? So this is, it really depends on your specific situation, but under the prosecutorial discretion memo that was released, special immigrant juvenile status is specifically listed in there as a reason to dismiss. So at least OPLA here in Memphis is more than willing to dismiss these cases or to join motions, and then we file them with the court. I haven't had a judge deny a joint motion to dismiss when it's on that. Same for if a child has an asylum application pending with CIS, they will often join motions to dismiss in those cases too. And so definitely, again, depends on your local jurisdiction, but okay. It's taking the Potomac Service Center 10 to 11 months to process EAD. Yes, that's fact. It takes forever and it's very frustrating.
Stacey, sorry to interrupt, but would you mind going back a slide so that people can see the how to get involved page? I think there was a request for that. Oh, maybe it was just more information. Yeah, this one, how to get involved. So while you're answering questions, people can access those. Thank you.
Yeah. Okay, Kimberly asked about SIJ approved kids with no priority date or priority is not current that are in court. Are you recommending admin closure or termination to wait it out? What happens if you get to an individual hearing with no priority date? So yeah, Kimberly, this is exactly, so I'm in the Sixth Circuit and OPLA takes a position in the Sixth Circuit that we don't have administrative closure. And so my only option is to get the case dismissed. I personally think that the dismissal over admin closure is probably better unless the kid has, you know, I know some judges let you file the 485 before the court to get that work permit. And then in that case, I would want to admin close. And so again, balancing those different considerations. If you get to an individual hearing date and the priority is still not current, one of two things could happen. So one, the judge could continue the case to another date. Or if you get a less friendly judge, the judge might order the kid removed because they don't have any relief before the court. Unfortunately, we have a judge in Memphis that was doing exactly that. So she wasn't even setting individual hearing dates. If we were at a master calendar and the prior date wasn't current, she was just ordering the kid removed, right? And then we had to appeal all those decisions, and it was a pain. But definitely, especially if you're representing a kid that is in that big backlog, I would definitely recommend getting out of court if you are able to. Let's see. Can a USC via SIJ file for a non-abandoning parent? Angela asked. So Angela, I agree with you that the answer is probably no, but it isn't settled, right? That you know, I think the general consensus is that it's no, but I don't know anyone personally that's tried it to see whether it would actually work or not, but I would imagine probably not. Let's see. TPS applicants must be present in the US with admission or parole. No, that's not right. So even if you entered EWI, you can still apply for TPS. How often are TPS dates amended? It really depends on the administration as to whether they want to extend TPS or not. And so, you know, I mean, it just depends, right? Usually if a country is coming up to the end of their current TPS designation, you're going to start, you know, seeing some kind of response from the government, right? So either it's TPS is going to be ending or TPS is going to be extended. Let's see. Staying on the TPS track, any concerns if TPS recipient travels back to home country? So there is not actually concerns, right? So the TPS country, it doesn't necessarily matter whether it's quote unquote safe for that individual. It's more of a countrywide issue, right? And so you can travel back for a period of time, but it doesn't, you know, it doesn't affect your TPS at all. So definitely not a consideration there. Okay, so SIJ, If the child's here in the US on H4 status and one parent abandons him or her, can the child apply for SIJ even though she has H4 status? Can those non-immigrant immigrant applications run simultaneously? How would this affect abandoning parent? Okay, so yeah, so even if the child has some other kind of status, you can still apply for SIJ. So for example, I have a number of clients that have DACA that we then applied for SIJ. And because DACA doesn't have that pathway to residency, we were able to apply for residency based on the SIJ. Those kids get the benefit, the double benefit, right? That they have the protection from DACA, they get the work permit from DACA, but they do have that path to adjustment. How would this affect the abandoning parent if he or she still has H4 status? So in terms of the SIJ specifically, I mean, the child would not be able to petition or anything for the abandoning parent. How that affects H4 status, that's out of my wheelhouse. So I don't know the answer to that one. What happens when the appointed guardian dies? This is a hard question. I think it depends on what the status of the SIJ petition is. So, I mean, there's the initial consideration as to, where is this kid living? Does he need a new guardian appointed for just like everyday life, right? To be able to make those decisions, that kind of thing. So that's an initial consideration. In terms of SIJ, if the SIJ has already been approved, then I don't necessarily think it's necessary to do a new 360 or amend the 360 or anything like that. I would just caution to make sure that the child is in a safe place, has a guardian, somebody to take care of them. Okay. Rachel asks about whether a kid who's been granted SIJ but then adjusts through asylum, U visa, or T visa can then petition for their parent. So I know that this is definitely a discussion that is out there. I haven't done a case like this, but I would imagine that could still work, right? Because you're not petitioning through SIJ, but I don't know. I don't have any personal experience or know anyone that has to really have that clear answer. I don't know, Shakira, if you have.
No, not in that situation, but I did had a family petition that they were requiring me a lot of things. So I submitted an SIJ, so that I have a plan B in case of in case the family petition doesn't go through. And the SIJ actually have run like faster than the family petition. I don't know why. So you can apply for multiples as long as you're saying the truth and you're filing a complete application. I think I don't know. That specific situation I haven't seen it.
Yeah. Okay, so Sheila is doing an assessment with a potential client who's 17 years old, entered US with two of her sisters. Parent is back in Afghanistan. Will she be eligible for SIJ since she's not able to return to Afghanistan? So I think that requires more information. I would want to know, it says the parent is back in Afghanistan. My question would be, where's the other parent? And then I would want to know, is there still a relationship between that parent and the kids here in the United States? I've had some clients, parents who have been deported from the United States, and then they basically just like go MIA, that they don't know where this parent is, they don't have any contact, and then we can make the argument that they were abandoned. But if the parent, say, is deported and they are remaining in, regular contact and that kind of thing, that gets a little bit harder to argue that they've abandoned. But it kind of depends on your state law and whether your judge is willing to sign an order talking about abandonment or neglect or anything, but just simply not being able to return to Afghanistan isn't enough to qualify for SIJ. Shakira, do you want to answer the asylum questions?
Yeah, it says since juveniles are not subject to the 1 year filing deadline, does that mean they can file for asylum even after they're older than 21? Okay, so yeah, remember that we have the 1 year deadline for asylum. It doesn't apply to unaccompanied children, but when you are 21, you're not considered a child. So my recommendation is, if you're close to 21 and you have asylum flags, apply for asylum. If it's an unaccompanied child, you have the option of applying in USCIS. But remember that, asylum in immigration court, it's, you need to know your court. And for example, like I said, Texas, the denial rate is very high. And the consequence is that your client will be removed unless, the judge grant CAT or withholding. So you have to take all that into consideration. Every case is different and you need to do, what's best for your client.
Okay, question from Christine. How slow is a visa bulletin moving for those countries with backlog? How many years do they usually have to wait? That is an impossible answer to answer unless you have some kind of magic ball. But we had seen, so before COVID, we were seeing just like a slow move. Then during COVID, because the SIJ, the EB4 category, also has other types of people that qualify under that category, we were seeing that because the consulates were not open or having interviews for certain types of cases, that SIJ actually moved along really quickly, right? Because the kids were still able to adjust here in the US. But then, we got to this month and then it regressed 2 years, right? So it's really a crapshoot. What I'm telling my clients that are applying for SIJ now is that my best guess is going to be 3 to 5 years before they'd be able to apply. But it's really, who knows, right? That's just, I don't know that anyone has answers to that question. Between U visa and SIJ, which option's better or faster? It really kind of depends on the specific facts of the case. I personally would probably pursue both of them because you never know what's going to happen. SIJ could be stuck at this May 1st, 2017 date for 2 years, right? We have no idea. There could be a change in, Congress could get its act together and allocate more U visas, right? And then all of a sudden the U visa backlog goes down quickly, right? It's kind of a crapshoot. And so I would definitely suggest doing both if possible. If a child has approved SIJ but decides to marry before AOS, they're no longer eligible for SIJ-based AOS. That's correct. They have to be on married through that whole process until, like I always tell my kids, until you have your green card in your hand, you need to not get married. Unfortunately, not all kids that then, they get to 19 or 20 and they just want to get married. And so that's why I regularly remind my clients. One other similar question that I get is, what if my SIJ client has a baby? It's fine, right? It's depending on their life circumstances, may or may not be fine. But for SIJ adjustment, that doesn't matter, right? So I tell my clients, you can have a boyfriend, you can live with your boyfriend, you can have a baby with your boyfriend. I don't care, right? That's your personal decision. Just don't get legally married. Okay. Have you ever seen the visa bulletin jump by a large amount of time? Yeah, we've had some, I mean, a large amount for immigration purposes, but you know, a couple of months at a time, that's definitely happened. And it's really great when it happens, except then you have, you know, a whole bunch of clients eligible for residency at the same time, and then you're just extremely busy, but it's a good busy. If one parent flew, oh, I guess we're out of time. One question I just saw pop up: if an SIJ applicant has previously been ordered removed in absentia, what happens? So basically, you need to you apply for the 360 just like you normally would, regardless of that that order of removal, whether in absentia or not. But before you do the residency application, you have to reopen that removal order, right? So under the current PD memo, I would request DHS join a motion to reopen the case and dismiss the case, so then they can adjust status under there. But you do have to deal with that underlying removal order in order to adjust. I don't know, Emily, were you going to jump back on? Somebody was going to jump back on to move on to the next panel.
Yes, thank you so much, Stacy and Shakira, for such a wonderful presentation and for answering so many Q&As. And so now we will take a 10-minute break, and we will see everyone back at 1:20 p.m. Central Time for session 2, Practice Before USCIS and Removal Proceedings 101. And in the meantime, please enjoy this short video from our Call to Pro Bono webinar from October during Pro Bono Week while you stretch and grab a snack.
I had none. And there's no question it is, you know, it is complex, but not that complex. It's not, I would consider it easier than tax law. I did a tax law project as this 1L summer, and I never wanted to touch it again because it was so complicated. Immigration is hard, but it makes a lot of sense. It makes a lot of intuitive sense that what you're arguing for, your advocacy, and what you need to put together. And there are really wonderful people who help you with it, right? And so you're not expected to suddenly just, you know and understand the INA and all of the procedures to get into immigration court. You have mentors everywhere where you can ask every little question, and they're really great about helping you. So even though I knew nothing, I've come to know a little bit more now, and so that's how I supervise a lot of cases. But you don't have to know anything going into it, because there's a lot that you can learn, and it's really cool. You just need some people skills.
Yeah, I'll say, I was a corporate transactional and IP lawyer. So not only did I not have any experience in immigration, but I didn't have any litigation experience either. So when I went before the immigration judge, it was kind of my first time representing somebody in court. So with that background, if I can do it, you can do it.
I volunteered a long time ago, so I'm sure it's even better now than when I volunteered, but when I did it, it was great. So I actually flew to Harlingen, met with the ProBar team. They put us in a room where they just trained us. They trained us on everything, on how do you get to know your client, and how do you interview them, and things that I hadn't thought about, like, the client might not want to tell their entire life story with all of their most sensitive, traumatic, experiences in your first meeting. Things that I'm sensitive, but just things I wouldn't have necessarily thought of. And over time, they taught us that. They taught us sort of, what are the legal requirements and how do you prove it up? And, procedurally, what's a master calendar hearing and what's a merits and what do you have to do at both? And then at every stage, there was someone available. And so, if I needed to, if I had a question about how to file something or how to serve DHS or how to do anything, my first case, I didn't know how to do any of it. And so I was on phone all the time, calling someone at the pro bar number, and, and someone would always answer and would always give me, would give me help. And so, and there's great mentors too. And so I remember the pro bono lawyer who presented with Meredith, Bob Etner, and he said, I could call him, he was like a private lawyer, had really nothing to do other than being another volunteer lawyer. But sometimes I would call him and he would give me ideas. And so that's what's so cool about volunteering in this, is that you have this incredible community of lawyers who care and who have huge hearts. And those are the types of people that you want to mentor you. And so I was a recipient of that. And so I am so happy to share that. So let me be your Bob Etner. Let me be your Meredith if you take this.
I started with IJP. They provided me with a lot of background information on the client. And then they connected me to IJC, which has the most incredible online tools. I felt supported every step of the way. There were online tutorials that explained every step of the process. It was like everything from like the basics of immigration law to like detailed sample forms, sample filings. And one of my favorite things, just talking, adding on to the whole mentor thing, they have regular office hours. So 3 times a week at a set time, you could just, Zoom in now, right? Because everything's on Zoom. You could Zoom in and ask your questions for to an experienced staff attorney that they had available to answer every single question. Like, I remember the first time I was filling out a form, like I didn't know which box to check about something, and I'm sure she had answered the questions like 50 times before. But she was so gracious and explained, why this was the particular way that I wanted to complete the form. So I would say that, over the 2 months I was handling the case, I was probably on once or twice a week. And I also never felt like I was imposing, because it was already built into somebody's schedule. So it's not like I had to reach out and set up something. It was just automatically there for me. And when I got to the point where some of the questions were more challenging around whether or not to file a merits matter, then I got referred to someone else who was an expert in this area at IJP who could help me out with that aspect of it. So I really, felt 100% supported, even at my really basic 101 level of knowledge and expertise.
This is the way I think about it, and I hope this helps you with a construct. There is no question that when you start, and in fact, still to this day, I feel like I have a greater learning curve on my pro bono matters than I do on my regular client matters that I do, from day in and day out, because it's not, 90% of my time is not spent doing it. So there's always a little bit of a learning curve for there. But at the beginning, it's a huge learning curve that you can feel like overwhelmed. So I can't do it because they just need an immigration lawyer, because an immigration lawyer would do a better job than me. That is a very natural thought process. Here's the reality. They can't afford the immigration lawyer, and the immigration lawyer can't always do it for free, because the immigration lawyer has to make a living. And so the only people who can do it for free are people like us who do it pro bono. And that means there's a learning curve. And the way I sort of got myself past that learning curve and to determine, like, it's okay. I might make a mistake, and it's okay. And the reason it's okay is because if I didn't show up, if I didn't do it, do you know who would be standing next to them? It wouldn't be the seasoned immigration lawyer. It wouldn't be the other person who I think is so much better than me. It would be them alone, not even necessarily speaking the language, and maybe with a translator who doesn't even speak their dialect, knowing nothing about the law, nothing about the immigration process. And so for me, the thought process is, I may not be the best immigration lawyer in the world. I'm probably not, but I am way better than them being alone. And them having me by their side increases their chances of winning by like manyfold. I don't even know what it is. You can look at it statistically, but it is huge. Like their chance of winning, if I am simply showing up in the room, is way higher than if they were alone. And even if I lose, even if I don't do it, the best job that someone else might have done if they had been paid, they have an impression of America that is totally different than standing in a cold courtroom with no one advocating for them. The greatest part about this country is that we have this beautiful system where people can come from all over the world. And if they have a reason to stay and we have an ability to get them to stay, they get to stay. And we are welcoming, and the welcome that they see is us. We are that welcome. And so, for me, is it there a learning curve? Yes. Is it hard? Sure, it's hard. But I know that I know way more than my client from Burundi who has only graduated from high school or may not have even done that, right? And so there's no question the knowledge that you bring, even if it's just I went to law school or I became accredited and learned this, it's more than they have. And so give it, share it, and be that welcome to America that they need.
Hi, everyone. Welcome back from the break. My name is Yasmin Yavar. I'm a senior staff attorney here at CELA, and I am so pleased to introduce our next speakers who are going to talk about practicing before USCIS and removal proceedings 101. And I know some of you had questions from the prior session that actually might be answered here, so stay tuned. Our speakers are from the Florence Immigrant and Refugee Rights Project, also known as the Florence Project. They are Roxana Avila Campanu and Casey Dempsey, and I'm so glad to have them join us. Roxana was born in Honduras and immigrated to the United States as a young child. She grew up in Indiana and attended Indiana University. She earned her law degree from Boston College Law School, where she immersed herself in the fields of immigration, law, and juvenile rights. And she joined the Florence Project as a staff attorney with the Children's Program in September of 2016 and held positions as a pro bono mentor and pro bono managing attorney before transitioning to their Children's Program manager in January of this year. Casey is a pro bono mentor attorney with the Florence Project, and she mentors pro bono attorneys in assisting unaccompanied children with their asylum and special immigrant juvenile status claims, as well as other forms of legal relief. She began her career as a civil litigation attorney in 2016 and transitioned to immigration law in 2019. Casey has worked for the Florence Project's children's team for nearly 3 years. She has a passion for representing children and giving them a voice as they navigate paths to relief in the immigration system. So without further ado, I will welcome you both. Thank you so much for being with us, and please feel free to share your screen.
Hi, thanks, Yasmin. You think I would know how to do Zoom by now. Good morning, everyone. My name is Roxana Avila Campanu. I'm the program manager for the children's program at the Florence Project here in Phoenix, Arizona. And we are here today to talk about EOIR and USCIS, which is just two of the acronyms we're going to be throwing at you today. So that would be EOIR, Executive Office of Immigration Review, aka Immigration Court, and USCIS, which is United States Citizenship and Immigration Services, which to our children clients we call the Office of Immigration. So we also have today here Casey Dempsey, who, as Yasmin mentioned, is a pro bono mentor. So before we begin, I want to just give you a little overview of who we are at the Florence Immigrant and Refugee Rights Project. We're the only organization in the entire state of Arizona that provides free legal and social services to men, women, and children who are in immigration custody. And we've been doing that for over 30 years now. On any given day, there are approximately 7,000 immigrant adults and children detained within our state's borders. And in case you haven't heard yet in these presentations, immigration is a civil proceeding. So that means that there's no right to a government provided attorney through this process. And so without representation, many immigrants will lose their cases and get sent back to those conditions of fleeing, which could lead to a death sentence. And so we're eternally grateful to pro bono volunteers who help us fill in this gap and provide free and competent representation to folks so they don't have to go through this process alone. So just to give you a little roadmap of what we're going to be talking about today, Casey and I do want to mention that we work with children, and so we are very well versed with unaccompanied children. We are going to be talking a little bit about adults and families, but we want to give you a little overview of what it means to be an unaccompanied child, because it does play into the differences in practice in these two settings. Under the law, it's unaccompanied alien child, UAC, but we prefer to call them unaccompanied children and leave out the alien and just focus on the fact that they're children. So we're going to talk about who they are. We're also going to give you a little bit of an anatomy of what it means to work in EOIR and USCIS and those different proceedings, as well as talking about adjudications and jurisdiction in those two venues. And finally, at the end of this presentation, we provided a resource guide if you wanted to do some light reading, but we won't be going over all of that. Is just for you to have as a reference later. And then finally, we'll reserve some time to answer some questions. So before we begin, just to give you a visual of what it's like to be an immigration attorney, we are juggling lots of different things in different areas. There's lots of players in the field. Sometimes it does feel like you have to look into a crystal ball and try to anticipate what's going to happen. And sometimes you're putting out fires, whether it's from your clients or from the government. And so it is a crazy field. And so we definitely recommend having a good mentor in your area who can kind of guide you through these hoops. But at the end, when you give your client that green card, you all celebrate together, and that feeling is just so special and makes you forget everything else that happened. And so just wanted to give you that update because this presentation is long and it's definitely doesn't cover everything that has to do with immigration, but we're hoping it's a good primer to get you started. So without further ado, I'll throw it off to Casey to get us started.
Good morning, everybody. We're going to talk a little bit about unaccompanied children, kind of give you a definition, and then talk about the different sources of law that create protections for unaccompanied children. So the definition of an unaccompanied child is a child who enters the U.S. without a valid entry document and who is not accompanied by a parent or legal guardian. And to be classified as an unaccompanied child, you have to be under 18 years of age, you cannot have lawful immigration status, and you cannot have a parent or legal guardian in the US that's available to provide care in physical custody. And one of the sources of law for protections for unaccompanied children is the Flores settlement. And this was a 1997 settlement that improved the standards for detention, release, and treatment of minors in immigration custody. So under the Flores settlement, unaccompanied children have certain rights. They have the right to be detained in the least restrictive setting. So if there is a sponsor, even if that person is an unrelated sponsor, the child should be released so that they can be out in the community and not in a detention facility. Apprehension, they have to be in safe and sanitary facilities, and they have to be transferred out of those border shelters within 3 days. And that's because those border shelters are not child friendly. They don't have access to recreation. They don't have access to education. And so they have to be transferred to an Office of Refugee Resettlement shelter within 3 days. And then custody, they have to be placed in a state licensed facility. And there is a policy favoring release, which includes release to non-parent relatives and other placements with a sponsor agreement. Another source of law for protections for unaccompanied children is the TVPRA. The official name is the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008, but we use the acronym TVPRA when we're talking about this law. And this creates asylum protections for unaccompanied children. So I think as you might have heard in the last presentation, the 1-year filing deadline for asylum does not apply to unaccompanied children. Another important protection out of the TVPRA is that the initial jurisdiction of an unaccompanied child's application is with an asylum officer at USCIS. So they get to apply before USCIS so they can have an interview, which is a less adversarial setting than in court where they would be subject to cross-examination. They also have expedited removal protections. They sometimes can be assigned a child advocate, usually through the Young Center. And then it also expanded protections and eligibility for special immigrant juvenile status. So it allowed these unaccompanied children to apply, whereas before the TVPRA, it was only children in foster care that could apply for special immigrant juvenile status. This law expanded it. Now I'm going to talk about the anatomy of EOIR and removal proceedings and kind of how the process works when you're going through. But first, I want to talk about some of the commonly referred to federal agencies with immigration responsibilities. The big three that we work with all the time is the Department of Justice, which is the big umbrella for the Executive Office of Immigration Review, which is just a fancy term for the Immigration Court. There's also the Office of Immigration Litigation that falls under the umbrella of the Department of Justice. And then we also interact quite a bit with the Department of Homeland Security. USCIS is one of the agencies that is under the Department of Homeland Security. Immigration and Customs Enforcement and Customs and Border Protection are also part of the Department of Homeland Security. And then the Department of Health and Human Services oversees the Office of Refugee Resettlement, which contracts with local shelters, state-run shelters, or state-accredited shelters in every state that detains unaccompanied children until their 18th birthday. There's three other agencies that we don't interact with as much, but the Department of State, the Department of Labor, and the Department of Education also have immigration responsibilities. So what is EOIR? It's under delegated authority from the Attorney General. They conduct immigration court proceedings, appellate reviews, and administrative hearings. And it's an office within the Department of Justice that's headed by a director who reports directly to the Deputy Attorney General. And there's a lot of different people that you will interact with when you are in immigration court. There's an immigration judge that oversees the proceedings. There's a Department of Homeland Security trial attorney. They represent the department, and they're kind of, you want to compare it to a criminal proceeding, they're the prosecutors of the case. Your client will be referred to as a respondent, and then the attorney for the minor or the client is, the attorney representing the respondent. There's usually an interpreter. There's a judicial assistant that assists the judge with calendaring and looking at different dates. And then there's also a bailiff that keeps order in the court while proceedings are going on. And this is a little chart that just kind of walks you through the different steps in immigration proceedings and removal proceedings. So the first thing that happens is the Department of Homeland Security initiates the action by filing a notice to appear with the immigration court. And then the first kind of hearing is called a master calendar hearing. And that's a very administrative hearing where you address pleadings, you will identify different forms of legal relief, and you can also challenge the notice to appear in those master calendar hearings. So some of the different things that can happen is you can identify relief, you can terminate proceedings, a judge can order removal or deportation, or a client can ask for voluntary departure during those master calendar hearings. But as you go along in the process and you get to the point where you're ready to present the case in front of a judge, then the case would get scheduled for an individual merits hearing. And then the judge will make a decision, and the judge can either grant the relief, again, terminate the proceedings, removal or deportation, voluntary departure, or if the relief is not granted, the Department of Homeland Security or the respondent or both can appeal to the Board of Immigration Appeals. And then after an appeal to the Board of Immigration Appeals, if it needs to be appealed further, it would be appealed to the federal court in the jurisdiction and the circuit that covers your jurisdiction. So in Arizona, where we practice, that would be the Ninth Circuit, but just depending on where you are would change the circuit court that a final appeal would go to. And then there's different types of proceedings. There's in-person proceedings, video teleconferencing, and telephonic. During the pandemic, we've had a lot of video teleconferencing and telephonic appearances in court, but at any time, even if your case is going to proceed in person, you can file a motion to appear telephonically or by video teleconferencing if that is more preferable for you and your client. And this is just a picture of what the inside of an immigration court looks like. In that big chair in the back behind the big desk, that's where the judge sits. And then over behind the computer is usually where the judicial assistant will be. There's an interpreter. A lot of times they'll sit at that desk with the microphone. And then the two different desks that are closer to the bar, they are where the at one desk will be the Department of Homeland Security attorney. At the other desk will be you and your client. And then behind the bar is where everybody sits while they're waiting for their immigration case to be heard. And something very important to note about immigration court, it is not an Article 3 court, which means it's not an independent judiciary. It's an administrative court that falls under the executive branch, and the judges are appointed by the executive branch. So, but something important to note is that circuit and Supreme Court decisions can still create binding precedent for your cases. And then EOIR also looks to the Board of Immigration Appeals, which is the appellate body that governs all immigration cases for controlling or persuasive case law. The federal rules of evidence, they do not apply in immigration court, but there are a couple of issues where you can bring up the rules of evidence. One would be relevance, and another would be anything that has to do with due process. And then the rules of civil procedure also do not apply to immigration court. That is replaced by the EOIR practice manual. And when we get to, when you get the resources, there will be links to this practice manual. And it looks like Emily also linked it in the chat. And then interpretation, the vast majority of our clients need an interpreter. And that interpreter is provided at government expense. And the court is going to provide those interpreters that are going to be placed under oath. And this is because respondents have the right to interpretation in their best language. This means that they can meaningfully participate in their immigration proceedings. It's a matter of due process and fundamental fairness. So practice pointers to always verify your client's best language before the hearing, and then keep in mind the cultural context when you are asking the client for their best language. And you want to insist on interpretation in the child's best language. The judge may not grant that request, but you are at least laying the record for appeal later on if that's not granted, and then you go to appeal, that's something that you could bring up. So different things that can happen at a master calendar hearing. It's very similar to an arraignment. At some point during a master calendar hearing, your client will plead to the charging document, which is the notice to appear. It's also where removability is established. It's a time and place to narrow the legal issues in your case. And then it's where you can sometimes file applications, for example, for an adult case, you can file the asylum application, or you can also be giving the court status updates for cases that are filed or forms of relief that are filed before USCIS. The judge can set deadlines for filing. And then at some point, a merits hearing can be scheduled or a hearing for contested matters. And you can ask at a master calendar hearing for a continuance if for whatever reason you're not ready to proceed to a merits. So we're going to kind of break down a notice to appear for you. It is the charging document. It's what starts immigration proceedings, and it's filed by the Department of Homeland Security. The requirements for the NTAs are set forth at these different statutes. and it has to be properly served before it can be filed with the court. Another important thing is that the respondent has to receive 10 days notice before their first hearing. So that notice to appear cannot be filed, or the hearing cannot be set less than 10 days after the notice to appear was served and filed. And it does classify respondents under an alien category, and it contains factual allegations to support the charge of removability or inadmissibility. These are the different things that the notice to appear must contain to be valid. It has to contain the nature of the proceedings, the legal authority for the proceedings, the allegations regarding the violation of law, the charges against the respondent and the statutory authority, has to include the date, time, and place of the hearing, a notification of the respondent's right to be represented by an attorney. It has to have a notification of address and phone number requirements. It has to include the manner in which it was served, and it has to be served in person, or if personal service is not practicable, through mail to the respondent. And you're going to check for signatures to see when that was served, by whom, and how it was served. And there are some child-specific service rules for the notice to appear. In every jurisdiction, for children under 14 years of age, the notice to appear has to be served upon the person with whom the child resides whenever possible. The department will also serve a near relative, guardian, committee, or friend. Also, when a child is released from ORR custody, the child's ORR sponsor should also be served with a notice to appear. But you always want to check with a seasoned immigration practitioner in your jurisdiction, because there are also different service rules that apply for different jurisdictions. So for the Ninth Circuit, which is the circuit that we practice in Arizona, when a minor is released to an adult custody, the department has to serve notice of the minor's rights and responsibilities upon the adult if the minor is under the age of 18. So they're going to have to reserve that notice to appear if a child is released to an adult if they're under the age of 18. And that's only in the Ninth Circuit. So definitely check your jurisdiction. And then for detained clients, this again is in every jurisdiction. If the department serves the notice to appear while the child is in federal custody, meaning while they are at an ORR shelter, the service should also be on the head of the ORR funded facility where the child is. And so this is what a notice to appear looks like. This is part of it. And you'll notice at the top in red, it says UC. That is because this is a notice to appear for unaccompanied child. The first section of the notice to appear is going to list the category and the manner of arrival. So in this case, this client is an arriving alien. It's going to have a filing stamp, so it's going to note the date that the notice to appear was filed. And then the factual allegations are down there. In this case, there's 4 factual allegations. These are the allegations that you're going to respond to when you are taking pleading. And then down here, it should have the hearing information. Something very important is it does have to include the date and time of the initial hearing. There's been a lot of litigation back and forth about whether this is good service and good notice if it does not include that information. But as it stands now, it does have to include the date and time of the initial master calendar hearing. And then you'll see the date that the notice to appear was issued. And you also want to look at the issuing officer, because only certain officers are allowed to issue the notice to appear. And you're going to look for their signature as well. And then down here is the certificate of service. It shows the date and the manner of service. And then very important, you want to look at the signature. So you want to make sure that it's signed by the CBP officer that served the notice to appear. But also in this case, you'll want to verify with your client if they were actually personally served, because in this case, it says subject refused to sign. So there is no signature from the respondent in this case. And then down here is the charge of removability. Again, you're going to want to check your jurisdiction, but also check for the type of case, because some of these charges do not apply. For example, this case is for an unaccompanied child, and the public charge rules do not apply to unaccompanied children, which is why you see that little W there. That means that when the pleadings were taken on this, that that charge was withdrawn, because it does not apply to unaccompanied children. And then if you're going to challenge the notice to appear, what this is going to do is it's going to shift the burden of proof to the government. It also preserves your arguments for appeal should you have to appeal your case. It could result in termination of proceedings if the notice to appear is not valid or if it wasn't served properly. And this all goes toward holding the government accountable for due process and fundamental fairness to the respondent. So you're going to want to look, when you're looking at the notice to appear, the different things you're going to look at is, does it include the correct manner of entry? So after you've spoken to your client, you're going to check with them, how did they enter? Did they, is the date that it says on the notice to appear correct? Does your client have any claim to U.S. citizenship? Because that is going to be very important when you're addressing the notice to appear in the allegations. Is the information in the allegation section correct, and was it obtained lawfully? Are the charges correct, and are there the correct signatures that show that it was issued properly and that it was served properly? And then these are different burdens of proof. I'm not going to go through all of this for you, but this is something that you have as a resource when the slides are shared. So when you're preparing for a master calendar hearing, you're going to want to go over the notice to appear, the form I-213, and the form I-770, and manner of service with your client. You're going to remind your client of the purpose of the hearing, and you're going to want to practice with them what it's going to be like to be in court. You're going to verify their best language, and then you also want to be prepared to address service and pleading. So you definitely need to review that notice to appear with your client. And also make sure you're familiar with your client's biographic data and the facts of their case. And then in preparing, you also might want to file a FOIA request and a record of proceedings request to EOIR so that you can get a list of everything that has been put in the record. You want to prepare your clients for what to wear to court. Something that we tell them often is something you would wear to church, or something you would wear if you were having dinner with your grandma. Definitely want to make sure that they're dressed semi-professionally, that they don't have any, offensive language on like a t-shirt or something like that. You want to double check the hearing date and time. And you want to be prepared with legal arguments and authority. And this is where pro bono mentors can be very helpful if you are taking on a case as a pro bono volunteer attorney, because we have a database of templates and can help you prepare arguments for your client's specific case. And then if you're in person in court, you're going to stand when the judge comes in. You're going to sit when the judge says you can be seated. And when you are speaking in immigration court, you do not have to stand, you can remain seated. And then different things that we wanted to talk about also with EOIR is termination, dismissal, and administrative closure. These are all forms of prosecutorial discretion. For dismissal or termination, you can ask for dismissal or termination of a case if the relief that your client is seeking has been granted already, if there is relief pending before USCIS. So if your client has special immigrant juvenile status or adjustment of status before USCIS, or they are waiting on their asylum application to be processed with USCIS, then you can ask for dismissal of the removal proceedings. You can also ask for dismissal or termination if the adjustment would be before EOIR, but your client prefers to proceed with their adjustment with USCIS. Or you can ask for termination if the NTA was improperly served, There are issues on the face of the notice to appear, due process issues, etc. And then if there's a pending asylum with EOIR, you do not want to dismiss or terminate a case. And that's because it could result in would result in abandonment of the asylum case. And it will also preclude your client from applying or renewing an asylum-based employment authorization document. And those work permits are very important to our clients. So you definitely want to keep the asylum case alive in front of the court so that they can continue to renew or apply for a work permit. And then administrative closure is another tool. It's not the same as termination or dismissal. It's just a temporary pause on setting hearings, but the case is still technically pending with EOIR, and it can be recalendared when you're ready to resume proceedings or schedule it for a merits hearing or adjust status before the immigration court. I'm going to turn it over to Roxana now.
Thanks, Casey. Okay, so that was just a quick snapshot of immigration court, and just to reiterate that this is probably has some bias towards the Ninth Circuit, and so definitely double check with practitioners in your area regarding maybe some of the practical differences, and also things can change from judge to judge, and so once you know the name of the judge on your case, it would be good to check in with somebody to see how that judge operates, because it can be different. So I'm going to talk a little bit about USCIS. So this, as I mentioned before, is United States Citizenship and Immigration Service. And this is the department of DHS that grants immigration benefits, and they also promote citizenship. So they do a lot of things like applications for family petitions, visa petitions, work permits, green cards, humanitarian benefits, and naturalization, among other things. So it's more of a process place. And so a lot of times clients can get confused because they're like, okay, immigration court, Office of Immigration, what's going on? So they are parallel, but they're not the same, and they have different functions, but sometimes they overlap. So we'll be going over that a little bit. This is just a view of what some of the USCIS offices could look like. This particular one does have plexiglass right now because of the pandemic, but others may not. And so this is another area where you can reach out to your local practitioners and see what it's like in your neck of the woods. So as I mentioned, adjudication and jurisdiction can be very different depending on where you're going. So I want to talk a little bit about I think I skipped the slide here. So basically, it just depends on where you are. So we have different forms of relief that can be filed in one or the other or both locations. So for example, unaccompanied minor asylum applications because of the TVPRA are going to be filed with USCIS, and defensive adult applications because they don't have that protection, if they're in proceedings, they're going to be filed with immigration court. A minor's asylum application could also be filed in immigration court because if they're here with the parent, for example, they may not be an unaccompanied minor, so they don't get those TVPRA protections. And so you would be filing that in immigration court. For adjustment of status applications or green card applications, it depends on the situation of the case. And so if you are not in proceedings, you'll file with USCIS. If you are in proceedings, it depends on your manner of entry, and I'll go over those details a little bit later. Immigration court will also adjudicate things like a 42B cancellation or removal. They can adjudicate asylums, but only USCIS can adjudicate things like family petitions, special immigrant juvenile status, work permits. And so there's overlap and similarities, but it's important to double check where it's appropriate to file your petition. So today we're going to focus on two common ones, which are asylum and adjustment of status. And so just to give you a refresher, I know you already went over this, but what is asylum in case you weren't at the first presentation? Asylum is a humanitarian visa for people who fear return to their countries because they've either suffered past persecution or have a well-founded fear of future persecution. And this persecution was perpetrated by the government or somebody that the government can't or won't control. And the persecution happened on account of the membership into one of these protected classes, which is race, religion, nationality, political opinion, or this catch-all membership in particular social group category, which is its own 2-hour-long presentation in itself, but essentially these are different categories. For example, LGBTQ folks would be in this, and so it accounts for different memberships. You have to, as I mentioned, meet the definition of refugee here, but also you can't be ineligible and you can't be barred. And so if you've already applied for asylum and it's been denied, you would be ineligible unless there's a changed circumstance. If you have a safe third country that you can move to, that could be an ineligibility for asylum. And then also you have to file within 1 year of entering the United States, except for designated unaccompanied children. If you've persecuted others, committed a particularly serious crime, a non-political crime, or if you're considered a danger to US security, including terrorism, you could be barred from asylum. And if you've firmly resettled in another country, you could also be barred for asylum. So those are the general requirements, but we're going to talk a little bit about the differences between an adult asylum and a child-based asylum. So for jurisdiction, as I mentioned, if you are in removal proceedings, the asylum case is going to be heard before the immigration court. If you are not in removal proceedings, you can file what's called an affirmative asylum with USCIS. So an important thing to remember with those affirmative asylums is that if your client is not in removal proceedings, you file the affirmative asylum, and if it gets denied, USCIS will refer that to the court, and it will likely get that NTA filed and start proceedings. And so that is a big consideration to think about when you're talking to your client. The 1 year bar, as Casey mentioned, it does apply to adults and non-unaccompanied minors. So you have to apply within a year of arriving to the United States. But if you're an unaccompanied, designated unaccompanied child, then you do not have to file within 1 year. And then derivatives. Applicants can apply for asylum with their children and spouses as derivatives, but the derivatives can also have their own asylum claim. So to illustrate this with an example, I've had minor clients who have had their asylum claim. They come with their children. And so I file for the mother and include the child as that derivative to that application. But because the mother and the child may have separate cases, I also filed for the child separately. So if the mother loses, the child can still have their own application pending. And so you have to be careful. And then when you're filing for derivative applications or separate asylum applications, it's really important to compare those applications to make sure they're consistent, because you don't want a spouse filing an application that's completely different from their other spouse, because then the credibility could be really messed up there. For unaccompanied children asylums, jurisdiction is over because of the TVPRA with USCIS, no matter if they're in proceedings or not. And so USCIS right now uses a once an unaccompanied child, always an unaccompanied child, unless affirmatively stripped. And so if your client was designated an unaccompanied child and they're still designated an unaccompanied child and no one has affirmatively stripped them of that designation, they should be eligible to file with USCIS. They may fight back, but there's litigation called JOP versus DHS, which is compelling them to go based off that rule. Again, there's no 1 year bar to filing for asylum under the TVPRA. But we do recommend that the asylum application should be filed before the 18th birthday, and that's to give them the maximum protection, because there is a case called Matter of MACO, which allows a judge to take jurisdiction over those asylum applications that have been filed after the 18th birthday. And so even though you could file it with USCIS and they can accept it, under this case, the judge can take jurisdiction and force the case to be heard in immigration court, so you lose the opportunity to get it heard at USCIS, which comes with its benefits that we'll talk about. So key takeaway, try to file those before the minor turns 18. So here's a step for a USCIS asylum application. Again, this could vary from area to area, and so it's good to double check with your local practitioners. And also a lot of these can be, a judgment call. So this is how we typically file them here at the Florence Project. So we complete an asylum application with the client and gather evidence, especially with the child client. We believe that this is important to get that declaration nailed down, because their memories could be fuzzy, or maybe things happen and they just weren't aware of the situation. Maybe there is, a police report or a newspaper article that we could file, but it doesn't match what the child is saying, or you could meet with them today, and then when you meet with them in 2 weeks, they've opened up and they're more comfortable, so things change or come out. It's important to get that nailed down so you are both on the same page about the facts, because credibility is the most important thing. Once we have that story nailed down, we file the I-589 application for asylum with USCIS, and then we wait for it to get scheduled. So once we get an interview notice, prior to that interview notice, we file a supplemental briefing for eligibility and other evidence. And this is another area to check with your local practitioners to see what your local office rules are, because they do vary from office to office. You also want to prepare the client several times. And then you'll attend the interview with the client. The officer will interview the client. You as the attorney will not be able to interject in that interview, but you will be given the opportunity to ask questions at the end and also give a closing statement to kind of summarize the case. Another thing I want to mention here is that at the Florence Project, we don't typically file those declarations with this packet, because we found that it just opens up the child for cross-examination. And if you get an officer who just doesn't want to grant it, they could say, well, you said you were in school in May, but the declaration says you're in school in April. So what is the truth? And then they make a big deal out of it. So we use the declaration to get the story straight, but we don't submit it. And then if it gets denied, that declaration gets sent to EOIR. And then maybe 5 years down the line, your client has to remember what they said 5 years ago. It can be a lot. So we typically don't submit that. Other people do. For an EOIR asylum application, this is one example. This one can vary even more because the judge in the same court, 2 judges can be very different. So double check that this is one example. Filing the I-589 application for asylum within a year and get that set for an individual hearing. Complete an asylum declaration with your client and gather evidence. File supplemental briefing and evidence, and the judge may want you to brief specific issues for a certain part of eligibility or whatever they want. You're going to prepare the client for several times for the hearing, because again, their testimony is going to be the most important thing. Then you will attend the hearing with the client, and DHS will cross-examine them. And then the immigration judge will issue a decision. And here you may have some expert witnesses or psych evals or other things going on, but this is just one example of what that could look like. So what happens after a USCIS decision? If it's granted, then your client is now an asylee. If they have a removal case, you can move to terminate it, and they can apply for adjustment of status after a year. If it's not granted, then it'll get referred to the immigration court for adjudication before the immigration judge. For an immigration court decision, if it's granted, then your client's an asylee and you can move to terminate those proceedings. They can apply for adjustment after 1 year. If it's not granted, you can consider an appeal to the Board of Immigration Appeals. So as you can see, EOIR is more adversarial. There's a trial attorney trying to trip your client up and cross-examine them and try to get the judge to deny this. And it can be, you have to convince an immigration judge. And immigration judges have wildly different rates of granting. There are different things that can convince them. So it's good to know your judge. For USCIS, it can be more child-friendly. Supposedly they're trained to be more child-friendly. There's no trial attorney trying to trip your client up. It's more of a conversation. You have to convince an officer. And if it's not granted, it gets referred to the immigration court for a second bite of the apple. So you can see that there are benefits to getting that unaccompanied child designation and filing with USCIS. In either scenario, asylum is very hard to win. It's very discretionary. It depends on the adjudicator and what circuit you're in. And also credibility is the #1 thing. So I kind of went over these as I was going through the process, but building rapport with your client and working in a culturally sensitive and trauma-informed manner is very important. We're asking our clients about the hardest moments of their lives, and so it's important to approach this with sensitivity. I mentioned about the declaration. I want to talk about the 589. We like to file what we call a bare bones 589. So laying out a cognizable claim that is enough to fit the definition of asylee, but general enough that you can adjust later. So if you give way too many details in the 589, then your client may change the story later, and that goes as a negative towards credibility. If you don't have enough, then you don't have a cognizable claim. And so it may be harder to build on that record. So make sure it's solid, but leave it general enough so that you can add. We recommend completing supplemental briefings for evidence and country conditions quickly, because the asylum interviews could be scheduled within 3 weeks, or you could have it scheduled in 5 years, but then once it does get scheduled, you only have 3 weeks. So it's good to get that completed as soon as possible. Determine the asylum office and see what their process is like, and prepare the child as many times as possible, or even the adult, because it's their word is the most important thing. I also recommend determining what your protected ground is as early as possible, so that you can really flesh that out and make a CGRS case assistant request, which is linked also at the end of this presentation. That's the Center for Gender and Refugee Studies, and they have like a whole library of briefs and templates and declarations, expert declarations that you can count on, depending, and they do it based on what your claim is. So that's asylum. Now we're going to talk a little bit about adjustment of status. This is the green card, the I-485, adjustment of status, legal permanent residence, permanent resident, LPR. These are all the same thing for that magic green card. So adjustment of status, it's very important to figure out who has jurisdiction. So USCIS has the legal authority to adjudicate most adjustment of status cases, except for the ones that the immigration judge has jurisdiction over. So even if a client is in removal proceedings, if they're an arriving alien, which Casey showed us on the notice to appear, if they're designated arriving alien or entered without inspection, that means arriving alien presented themselves at a port of entry. Entered without inspection means that they were apprehended outside of a designated port of entry. And so an arriving alien always can file an adjustment of status application with USCIS, even if they're in removal proceedings. And so you can see here the citations for an arriving alien. And importantly, even if there's an order of removal, if your client is an arriving alien, you can still file with USCIS. So here's how you're going to figure out where you're going to file this application. Is your client currently in removal proceedings? If they're not, file with USCIS. If they are in removal proceedings, go to step 2 and figure out how they entered. If your client is an arriving alien, then you file it with USCIS. If they're not an arriving alien, then you're going to file it with EOIR, or if it makes more sense for your case, you could try to file a motion to dismiss or terminate, depending on what the landscape looks like in your court, and file it with USCIS. So for example, for some of my clients, I don't want them to go through a cross-examined adjustment of status hearing. I find maybe it's more trauma-informed for them to go through a paper application that sometimes may not even get an interview. And so I may file a motion to terminate for my entered without inspections clients so that they can file at USCIS. And just so you know, this is all a big knot and complicated, so don't worry if you still don't understand. The important thing is to figure out what makes sense in your situation and what the legal venue is. So if you file in the wrong place, it can have major consequences, because sometimes USCIS and EOIR aren't really tuned into that jurisdictional question, so they may go ahead and grant it. And so if your client entered without inspection and they're in proceedings, and you file with USCIS, USCIS may give you the green card, and your client could live with that green card. But when it comes time to apply for citizenship, for example, USCIS may find out, oh, we shouldn't have granted that, you have to start over. And by that time, the visa that is the underlying basis for that application could be used up, and your client has to start all over, and they may no longer qualify for the same kind of relief. And so they could lose that chance. So it's very important to make sure you're filing in the proper venue. Another thing to look at is that different bases for adjustment have different requirements. So for example, special immigrant juvenile status has its own waivers and bars and requirements. Asylees have their own waivers and bars and requirements. So it's important to look at what that basis of your adjustment application is and figure out what applies to your client. And that's the end of the presentation. Here we have a resource guide. We just kind of popped in some things for you to look at. Maybe late at night you have trouble sleeping, you can look at this. So some important things we want to talk about, as Casey mentioned, discovery is super important. You want to see what's on the record, because again, credibility is important, but you want to see what DHS has on your clients so you can fight that. So here's some other resources. One thing I just want to highlight is the Office of Trafficking in Persons. It's a little bit outside of this presentation, but if you're working with children, we definitely recommend looking at an Office of Trafficking in Person request. They do monthly webinars to tell you who qualifies, but basically any child who has been trafficked at any time, anywhere in the world could receive an eligibility letter from the Office of Trafficking in Persons. If they're detained, this could help them get into a program called Unaccompanied Refugee Minor Program, where they can live with a foster family, and it's more child friendly. If they're not detained, they can have access to the Trafficking Victims Assistance Program, so they can get benefits like access to medical care. One of my clients got a phone and some food from them. So it's just, if you're working with a client who's a child, look into this. We just want to share this word. And so that's the end of our presentation. We do want to mention that we do have some cases available for mentoring at our office. We have a full service mentorship program, which means we pair you with a seasoned pro bono mentor and a legal assistant. We provide interpretation. We have a template bank of over 300 templates that we share given different situations and different cases. And we also count on the knowledge of our colleagues to keep you up to date on that cutting edge immigration law, because you remember the juggling, things happen all the time. And so we're really able to keep you updated onto what those changes are, and also give you a sneak peek as to the cultural sensitivity of your client's case and what this judge likes, what that judge likes. So if you're interested in a case with us, it's on Pro Bono Matters, and so you can definitely find it there. So with that being said, I think we can open it up for questions.
Yeah, and I see we already have a number of questions in the Q&A. So the first question is, if a person is under 18, but they arrive with a visa, they aren't technically a UAC, then do they have to abide by the asylum 1-year filing deadline? Yes, if they're not a UAC, even if they're a minor, then they would have to abide by the 1-year filing deadline for asylum.
Yes, and that's also a really good thing to point out. A child has to be designated a UAC. So if you have a client who meets that definition and they maybe have been here for a while, they may not have been apprehended, they may not have gotten that designation. So you would have to figure out how to get them designated so these protections can apply.
And then the next question is, so is a date to be set not adequate on a notice to appear? Yeah, like I said, there's been litigation that's gone back and forth on this, but I believe there was a recent case that came out maybe last month that says that the notice to appear does have to list the time and place, so the date, time, and place of the hearing.
I think for this question, you need to contact whoever's in your circuit, because it varies wildly. And so we may be giving you a 9th Circuit answer. And so it's really good for you to double check what the law is in your area and what makes sense. Also, what maybe some judges go for certain arguments and other judges don't. So definitely double check with practitioners in your area for what that answer is. Okay.
And the next question is, can you speak more about the we prefer to proceed with USCIS? Why would you do that, and on what grounds would this be granted? So this is a lot about what Roxana was talking about when she was talking about the different jurisdictions for adjustment of status. So let's say your client entered without inspection and they're still in removal proceedings, then that would mean that their adjustment, the court would have jurisdiction to adjudicate their adjustment application. But let's say for whatever reason, like Roxana, the example Roxana gave, if your client, probably might not do well with cross-examination and they'd rather adjust with USCIS, then you can ask for the case to be dismissed before the court. And then if the case does get dismissed, then you could file with USCIS because they would no longer be in immigration proceedings.
And I think another one would be, for example, this is like so getting into the weeds, but immigration court always uses a final action chart, and USCIS will use sometimes a dates for filing chart when it comes to the visa availability. And so this means that sometimes if your client is eligible to apply before USCIS, they could be eligible to apply sooner than if they were in immigration court to at least get that application filed and an EAD granted, which is a work permit. And so sometimes that could be a reason why you would want to ask for dismissal. As far as what grounds would this be granted, it really just depends on your local immigration court and your local DHS officers, because here, for example, I've just gotten some granted just based on the fact that they're eligible and they want to apply with USCIS. For my case, it was because we didn't want to go in person in immigration court. We wanted to just kind of do everything by paper. And in our experience, they haven't been asking for interviews at USCIS. So it's really a question of filing everything together, getting it there, getting it adjudicated, and then the green card gets mailed. Sometimes they do interviews, but it can be a smoother process for the client, especially if they've been really traumatized. And it's also, for me, easier to file one packet with everything than to try to figure out all the different moving pieces of immigration court. So it just depends on your case. It may not make sense for you to file that motion to dismiss to proceed with USCIS, but it's just an option I wanted to mention.
And then the next question, twice rejected Form I-589 of a derivative. USCIS says that there is a case already filed with his name as derivative. What to do to be successful filing his own application?
Yeah, so this is interesting to me. I know that it happens. I personally have never had this happen to me. I've gotten them all accepted. I don't know if it's because they're unaccompanied children, but I think this could be USCIS office specific answer that you could reach out to a local practitioner to see if there's something that works in your particular office. So we're with the Los Angeles Asylum Office, and they tend to be a little more friendly. And so maybe that's why I was able to do it.
And then this question is, if filing a separate asylum application for children, must they file their own pretrial brief and testify? Otherwise, if the mom loses, wouldn't the child? So when you got to the point of having a hearing for the child's separate application, yes, they would do their own pretrial brief. They would testify depending on their age. Sometimes if it was a baby, that's not really, they're not really going to be able to testify. But yeah, so the whole purpose of filing, if you're going to file with the child as a derivative, the whole purpose of filing their own application separate is because if the mother did lose, the child would still have a chance to get their own asylum application granted.
Yeah, and I think of it as, for example, let's say that the mother's claim is based on domestic violence, but the child's case is based on membership in a particular, like in a member of a race. Maybe their father is from a different race. So those are separate claims. And I believe that the child should have the right to go forward on that own claim as well. Okay. If you came with your spouse and children, the whole family group is in removal proceedings, do you need to submit an I-589 for each one in the same package? I do not know the answer to this. I don't know, yes, Yasmin or Emily, if anybody knows the answer to this. This is not our wheelhouse, and so I don't want to give you the wrong answer. I see Laura's typing an answer, so we'll go to the next one. Client submitted I-589 prior to the 1 year, but USCIS returned it because it was missing a signature. What options does client have? So I believe in that case, because it wasn't complete, you could try to argue that it was a clerical mistake and then refile it and ask them to honor the 1 year. Or you could argue that there are exceptions to the 1 year bar. So you could try to argue that this was, an exceptional circumstance. So you could look into the case law to see what sort of argument you would have against that. But they are pretty strict about that. I don't know if this is an unaccompanied child, if it's an adult. Those have different rules as well. Something that's an extraordinary circumstance for an adult or for a child may not be for an adult, and vice versa. So definitely looking at those options for what kind of arguments you can make. There's a lot of confusion about the address to send the DHS copies of the documents filed with EOIR. So if I'm capturing this question correctly, anything that you file with immigration court, you should be serving a copy to DHS, and you can find You can just Google what the address is. They're all listed on the ICE website, what the address is. So anything that you file with immigration court, you should file with DHS. But if you're filing, for example, special immigrant juvenile status, you're filing that in juvenile court, you don't need to file those documents with DHS, just everything that you file with immigration court.
I think we have time for one more question. What is the difference between an NTA and Form I-213? When reviewing the I-213 with a client, what is important to note or cover? So I can talk about this a little bit. The Form I-213 is it's almost like the interrogation form. So it's the form that's produced when they're interrogated by a Customs and Border Patrol official. And there's lots of really important things in that document to review with your client. I've seen the I-213 say that a child entered, for example, I had one where the I-213 said the child entered in Sasabe, Arizona, and then the NTA said that they entered in Lukeville, Arizona. And so I looked that up, and those two cities are about 300 miles away from each other. So it could be a way for you to challenge the notice to appear if you're saying, hey, there's information in this document that does not line up with the information in this document. So you kind of just want to go over the different things and what it says in the notice, in the I-213, to make sure that it matches with the notice to appear, but also to make sure that both of those documents are accurate with your client's memory of what happened.
I think one note about the 213, this can be our last thing, is that it looks like it's a transcript of a conversation, but it's not. It's like they choose the question and then type in an answer, so it can be very inaccurate, and that's really important. And also going back to the language issue before, double check your client's language, because oftentimes they'll do it in Spanish or they'll do it in English, and so that information is not accurate. And so these are just choice points for due process issues. So I think we'll leave it at that. We could talk forever. We'll leave it at that. Thank you everyone for your interest. And I'll tell you one thing, you'll never be bored in this area of law.
Thank you, Roxana. Thank you, Casey, so much. That was super helpful. And thank you for getting through all those questions. I'm going to share my screen now if I can. We're going to head into a break that'll actually be a little bit longer of a break this time. It's 15 minutes. This video that I'm going to play for you all is called Tu Futuro, Tu Voz, and it was a video that the Commission on Immigration put together with some help from SELA. It's for young adults who went through being in OR custody and having legal assistance and obtaining immigration relief. And they're just talking about what that experience was like for them and what it meant for them to have representation. So I'm going to play that for you guys now. Let me just gear it up.
Cuando vine en Estados Unidos a los 14 años, fue muy difícil.
Cuando tenía 16, mi planes no era venir aquí, pero de la noche a la mañana me propusieron venir y no lo pensé dos veces, simplemente tomé la decisión, dije sí. Al siguiente día ya estaba viajando.
Soy guatemalteco y ahora estoy viviendo en Galveston, Texas. Yo tenía aproximadamente 15 años y medio.
Yo era una de los niños que llegaron en el 2008. Yo tenía 13 años. La idea de crear este video es para informar a los jóvenes sobre la importancia de saber lo que es un abogado, saber lo que es una corte, saber el sistema de las leyes de aquí de Estados Unidos. Y la razón por la cual se me ocurrió la idea fue porque yo era una de los niños que llegaron en el 2008. Y yo no tenía idea de lo que era un abogado, no tenía idea de lo que era un juez, no tenía idea de cómo las leyes trabajaban aquí. So me gustaría como educar un poco más a las personas que no saben y que están en ese momento pasando como yo pasé hace tiempo.
Cuando yo entré a los Estados Unidos, lo primero que dije fue, voy de regreso a casa porque me agarraron. No tenía ninguna experiencia en nada, ni en estudios. Entonces, la esperanza era llegar y trabajar. Pero me agarraron y vi que todo eso ya se había acabado. Me transfirieron a unos lugares de casas, hogares, sin saber nada, no sabía, incluso yo pensé que ya iba para Guatemala. No me dijeron a dónde iba, por qué, ni nada. Al siguiente día yo le pregunté a un trabajador social, me dijo que tenía que ir a contratar a un abogado, ir a una corte.
La desconfianza que yo sentía con los abogados, y no solamente con los abogados, con la mayoría de los adultos.
Al principio cuando vi esos abogados así con traje y con sus corbatas y zapatos bonitos y dije, oh, santo cielo, ¿en dónde estoy parada? Y dije, y me preguntan, Nancy, ¿cuál es tu historia? Nancy, te preocupes, te vamos a ayudar. Y decía, pero ellos, no sé si es cierto, me van a ayudar o no. Estaba así confundida y mi mente en blanco. Y cada cosa que me decía, yo tartamudeaba, yo era una niña así, no fui a la escuela. Y con baja autoestima, ver una persona así en traje, me sentía menos, me sentía, pues era cierto, viendo a una persona con traje en mi país, donde yo soy, en el pueblo, las personas que sí están en trajes como para tenerles miedo, a mí me daba miedo, mucho miedo.
El último día de corte fue, y después al final ella vino y me dijo, ganaste tu caso. Y me dijo, son tus papeles, ya tienes tus papeles. Y yo me acuerdo que yo le había prometido a Dios hincarme y darle gracias.
Le pedí, me llegó la cita de la corte, mi maestra de inglés en clases. Le dije, mire, me llegó esta carta, ¿qué puedo hacer? Y me dijo ella, mira, tienes que conseguir un abogado. Un abogado es una persona que te va a representar y va a decir por qué tú estás aquí. Le va a explicar, va a hablarle al juez para decirle todo. Y le dije, pero no tengo dinero, no tengo nada. Y me dijo, no te preocupes, yo tengo unos contactos de unas personas que ayudan a menores, a personas ilegales, y no les cobran, es gratuito.
Esa experiencia fue dura porque es por parte de mi familia y honestamente me da pena decirlo, pero no tuve el apoyo de ellos en absoluto. Mis hermanos mayores, bueno, como yo era la pequeña de medio y decía, todo es mentira y va a ser por tu culpa que nos vienen a traer a todos nosotros. Pues ellos también son indocumentados como yo era antes, cuando estaba en el proceso. Y yo les decía, no es cierto, a mí me dijeron que sí puedo tener mis papeles en este país. Y apóyenme, ellos quieren que yo vaya a la escuela. Y mándenme en una escuela. Y ellos dijeron, no, olvídate de eso.
Fue difícil. Al principio no sabía si decir, no sabía si quedarme callado, no sé si seguir. Pero dentro de mí me decía, tú puedes hacerlo, es por tu bienestar. No te quieren, esta persona no está para lastimarte, no está para hacerte un daño. Solo quiere encontrar la manera de poder ayudarte. Me entrevistó y tuve el coraje de poder decirle todo lo que estaba pasando, por qué yo estaba aquí, qué era lo que yo quería. Y ella me dijo, ok, de esta forma yo te puedo ayudar. Este es el proceso que podemos hacer. Y me dice, si tú puedes, si tú quieres, podemos hacer eso, pero necesito que tú me digas que sí. Y le dije, sí, hagamos eso. puse la confianza, me decidí al todo por el todo. Dije, bien, no pierdo nada con intentarlo, pero voy a perder más sabiendo que no lo intenté. La forma de la que ella me hablaba, la forma de que ella me preguntaba las cosas, la orden que me dio en las preguntas, eso me hizo ver que ella quería ayudarme. Y eso me dio la confianza de poder decir, ok, sí puedo contar eso, sí puedo decir eso.
Al principio, como uno no entiende, todo es cosas que uno empieza a descubrir y dice, oh, esto es así, esto es así. Como decir, a veces estar haciendo un trabajo solo y luego viene alguien y lo ayuda es mucho mejor. Entonces, no desconfíes de los abogados. Cuando ellos se introdujeron a mí, me sentí bien con ellos. Estando durante un año encerrado, convivo con otros jóvenes que estaban en la misma situación, pero muchos jóvenes piensan, oh, porque tu caso va bien, mi caso también va a ir bien, pero lo que sí es que una parte que deben de entender que cada caso es diferente, no importa si estás junto con tu hermano, tu mamá o tu papá, cada caso es diferente y pues sí puedo decir que es única porque cada persona que estaba ahí decía, yo soy por esto, o yo simplemente me vine porque quería estar aquí, o yo me vine huyendo por violencia, o yo me vine por esto. Mi consejo es como hablar con la verdad, decir por qué razón llegaste aquí y seguir el proceso, seguir las reglas.
No era fácil volver a confiar en adultos, porque sentía como que ellos eran los que mandaban y ellos eran los que si querían hacer algo conmigo pues lo hacían. Pero poco a poco fui recuperando esa confianza y creo que, como vuelvo y repito, Laura estuvo allí ayudándome y diciéndome, no, eso no, si te pasó eso allá, aquí no te va a pasar, porque estoy aquí para ayudarte. Si tú fuiste abusada físicamente, te golpearon, eso no va a pasar aquí. No sabía qué era la corte, no sabía, en Honduras nunca me explicaron técnicamente lo que hacía una corte, para qué uno iba a una corte, el proceso de la corte, cuánto tiempo se tardaba, porque en ningún momento me imaginé que se iban a tardar casi un año para dejar saber mi decisión. Todos los sentimientos eran como un poco confundidos y a la misma vez daba miedo. Pensar en que si lo intento y luego no sale y me deportan, pero creo que fue una decisión que tomé en mi vida y fue la mejor decisión.
Yo sí lo entendí porque ellos me lo explicaron de la mejor forma y se puede decir están paso a paso con uno todo el tiempo. Cada cambio que hay en el caso, ellos vienen y lo explican y explican las opciones que uno tiene. Entonces, para mí, la convivencia con ellos fue de lo mejor.
Y me siento tan feliz y me sentí a la vez bien contenta porque ahí estaban ellos apoyándome. Me daban la mano y decían, tú puedes, Nancy, tú puedes, te vamos a ayudar, aquí estamos contigo. Me sentí tan feliz y cuando recibí la noticia, digo, wow, gracias Señor. Y yo digo a todos los que están ahí, no pierdan la esperanza porque siempre hay una esperanza. Y no, Canatacho cuando yo con Huachil, hasta hablar español y yo hablo con mamá y con la abogada lo haré y yo hablo yo viaje la Huachil que copta y ni cochiri quien toó y chilashin y lo que cojo no propósito. Y shakshuta ini cochiri y más cochiri y cochila Wetam que ikita que chajo español y herein o español chenap Macasta quinchao bien el español, but Shinwatama y Chanbiri quinchao español y it inglés.
Si yo pudiera viajar en el tiempo y decirle a mí misma a mis 13 años que no me preocupe, que confíe en el proceso, que tome las cosas con calma, que sí es un proceso fuerte y es un proceso difícil, pero es un proceso que al final vale la pena. Estás aquí, estas personas te están ayudando, ellos no están aquí para herirte. Creo que hablaría mucho sobre poder disfrutar, estar ahí en el centro y poder buscar esa persona de confianza y hablar, porque creo que es más el miedo de poder a dónde ir y hablar. Creo que muchos de los niños ese es el único problema que tienen, de poder confiar. Y creo que sería como decirle a mí misma, confía, está bien, todo va a estar bien.
Si pudiera regresar, creo, me diría que no tuviera miedo, me diría que tuviera fe, que había algo bueno por delante.
Fue difícil, pero fue un proceso que técnicamente ahora viéndolo, tuve que pasarlo para poder estar aquí y para poder ayudar a otras personas. Y creo que viéndolo del punto de vista de ahora es algo que todavía necesito trabajar, pero también es algo que me ha hecho fuerte, me ha hecho ser la persona que soy ahora.
Hello, everyone, and welcome back from the break. Thank you for watching that video during the break. It's now my pleasure to introduce our panelists for our final session today, which is on interviewing skills when working with children and families. Our panelists are from Safe Passage Project, which is a fantastic organization that gives lawyers to immigrant children in New York City and Long Island. And we're joined today by Nicole Johnson, who joined Safe Passage Project as a senior staff attorney in September of 2018. Prior to coming to Safe Passage Project, she was a senior staff attorney with the Immigration Intervention Project of Sanctuary for Families at the Bronx Family Justice Center, representing victims of gender-based violence in a variety of immigration matters, including U non-immigrant visa petitions and VAWA self-petitions before USCIS, as well as asylum applications, both at the asylum office and before immigration court. And before joining Sanctuary for Families, she was an associate attorney at Salman Navarro Law, where she also represented clients before the immigration court. You can read Nicole's full bio in the materials that have been handed out to all of you today. We're also joined by Alexandra Rizzio, who's a graduate of Fordham Law School and Columbia College. Alex has a long history of advocating for the rights of immigrants. Alex joined Safe Passage Project as a staff attorney in 2015, and she later supervised the organization's New York City team. Alex now serves as a managing attorney for training and partnerships at Safe Passage, where she develops litigation and technical assistance tools for attorneys and leads the organization's pro bono department. Again, you can read Alex's full bio with our materials, but I want to turn it over to the speakers now to give them time for their complete presentation. Alex and Nicole, thank you so much for joining us, and you can take it away.
Thank you so much, Stephanie. Hi, everybody. I am just going to get started by playing this slideshow And then I'm going to hand it over to my colleague, Nicole, to get started.
Absolutely. Thank you, Alex. Hi, everyone. Thank you so much for having us here. I just want to say first that video was amazing and super impactful. And I think it was a wonderful segue into our presentation today, which is going to talk about interviewing skills for children and families. As Stephanie mentioned, Alex and I both work at Safe Passage Project, which is an organization in New York City that represents immigrant youth before the immigration court and other forms of relief. Sorry, you can go back to the last slide, Alex, really quick. So in talking about the situation that kind of prompted our organization, and I think a lot of the work that a lot of you guys do, right, in the last there's been a lot of poverty and violence, and that has, sparked people to leave their homes in Central America primarily and venture here to the United States, which has resulted in, millions of people kind of coming into the United States and needing help. And so, next slide. So, at Safe Passage Project, when these young people are apprehended at the border and they leave OR custody and are brought to New York, they can find us. We represent these children in their real proceedings, as well as whatever form of relief that they are eligible for, which oftentimes is special immigrant juvenile status, as well as asylum. As I mentioned, the majority of our clients come from Central and South America, but we are seeing increasingly more clients from, Southeast Asia or South and East Asian countries, as well as other parts of the world. So when thinking about these young people, the young people who are coming here and fleeing their homes, a lot of them, of the young people that you guys work with and that we work with, will have had experienced some sort of trauma, whether it's at home, at the hands of their caregivers or other people in their communities, even on the way coming here and the journey to the United States, which is oftentimes a very excruciating and difficult journey, or even sometimes when they arrive here in the United States, sometimes, when they reunite with parents who they haven't seen since they were 1 or 2 years old, and then kind of reuniting or trying to kind of recreate that bond, oftentimes results in trauma. All of that to say, like I said, a lot of the young people, if not all, have experienced some sort of trauma. As we all know, trauma really does have a great effect on the brain, and it does manifest itself in many ways, right? So trauma memories are not stored kind of in the verbal part of the brain, but rather the part of the brain that's responsible for nonverbal communication, which means that it manifests itself in different ways, which can have a tremendous impact on your ability, like your representation of the client, and also the relationship that you build with your client. So some of the common manifestations of this trauma include flooding. So imagine situations in which, you have a client and you're trying to, right, as lawyers, we want to get the chronology of what happened, right? What happened first, and then how did that, move on to the next thing, and then what ultimately happened. And in trying to kind of get those affidavits, put together the affidavits and speak with your clients, a lot of times they might say something one day that's like, this happened when I was 6, or this happened when I was living here. And then as you continue to work with them, they might say, well, that happened at this other juncture of my life, right? And I think, the initial action is, why don't they remember something that is so traumatic? Why don't they remember when it happened? But that's, a product of flooding, right? So all kind of traumatic incidents or related traumatic incidents come to mind, and it really kind of blurs the situation, and people are really unable to kind of delineate what happened when. Minimization occurs when they basically kind of, it minimizes it, right? So it wasn't as bad as it could have been, or it was my fault. Oftentimes with abuse, sorry, I get distracted by chats and things. Oftentimes with abuse, right, you're like, maybe I deserved it, maybe it was my fault, I shouldn't have done this. And so a lot of the minimization that happens as a result of the trauma. Disassociation happens when people, sometimes they don't remember that things happened, right? Our brain is a very special thing, and it can block out memories, or it can make it as if you didn't happen. And so, you'll have one meeting with the client and you'll think that you have a pretty good story. And then the next meeting or 3 meetings down the line, or even sometimes in my case, I've learned at the asylum interview, that's something pretty significant that, would have really been nice to know and would have been helpful for us in our preparation of the case, that it actually happened. And, it's not that your client is lying, it's just really kind of a product of trauma and that disassociation. And then the other form is really physical reaction. So, anxiety attacks. I once had a client who, anytime we talked about a specific part of her case, would, start hyperventilating, start throwing up, and really kind of pass out. So it's, it's such an interesting thing how trauma affects the brain. I think the biggest thing to remember when working with clients who have experienced trauma is that patience is important. You really want to build that trust and kind of create a collaborative relationship with your client. Some of the things I think in the video that was mentioned is just like being clear about exactly what you're doing and why you're doing it, and making sure that the person that you're working with, the young person that you're working with, really understands each like step of the case and what's happening. Next.
Nicole, can I just jump in to note that when it comes to physical manifestations of trauma, I mean, really what we're looking at is the body going into flight or fight mode. And so, if, like Nicole said, your brain can shut down to protect itself from the traumatic experiences. And so when you're interviewing young people and families, just keep in mind that there is a lot happening that we can't see. And even though your client is probably doing the best that they can to explain their situation, it's going to take a lot of time, especially depending on the type of trauma that they have suffered. And just a quick note, we have some very silly GIFs or GIFs peppered throughout this presentation. It is not intended to make light of the subject matter, but I do think it's, we do as advocates, I think, need to have a kind of outlet. And at least for Nicole and myself, funny GIFs serve that purpose. So hopefully you will enjoy them. If you don't, you can maybe just put our faces right over that GIF and you won't have to see it. Okay, there you go.
So thinking about those things, when we meet with these young people, you meet with your clients, there's some things that you kind of want to think about before you start to meet with them, right? So, a lot of the young people in the video mentioned not ever having seen a lawyer or knowing what a lawyer was, or a judge or court. And so, really kind of making a concerted effort to explain who's who, like things that you might think are common knowledge or that might be common knowledge for us, really might not be for your client. And so, taking the time to think about things that that may be different, cultural differences, or and then explaining things in the system the best way that you can will go a long way towards building that trusting relationship. Thinking about court and what that system looks like. In New York, it's a huge federal building, and there's often security guards who are sometimes armed, and really kind of explaining, this is the place that you're going. There's no need to be afraid. I will be there with you. Let's talk about what it looks like. How do you get into the building? So a lot of those things are small, but will really make a difference in working with the young person. Also, really thinking about some things to the young person might not even be considered abuse or abandonment. Oftentimes, we have young people and you're going through their history and you find out that their parent used to hit them a lot when they were younger. But they'll say things like, but that's normal. That's just how it is. Or like, I was being bad. And so, that was right. And really kind of thinking about explaining to them how, it's not trying to make them feel that like what they believe and what they understand is not correct, but really just kind of breaking it down and saying, so according to the US law, this is what, it means to have been abused, or this is what it means under the law here in the US to have been abandoned. And so, these facts that you mentioned to me kind of fit here. But also just kind of, recognizing that it might take a little bit more work to kind of break down those, the kind of barriers to good communication and good understanding between, you and the young person.
And I just wanted to note, we have here this example of my Indigenous Guatemalan client. I put this here because, some clients might not have negative feelings towards the court system or attorneys. They might just feel like that system is not for them, or that they don't have a place in it. So I was working with an Indigenous Guatemalan family, and I was, trying to explain why we have to prepare in advance for court and why we have to do certain things before the actual court date. And the father of my client, who was a young boy, kept saying like, well, it's in God's hands and it's in the judge's hands. So we'll just show up and the judge will decide. And we had to have several conversations about the fact that in the United States and in the proceedings that his son was in particular, that's actually not how it works. And I think that was probably a product of just not like his community not having access to the legal system at all, or if they did, the result was kind of a foregone conclusion. And so he didn't have necessarily negative feelings towards the court system. It was just a matter of doing a lot of explanation about how participation is actually essential in a lot of these claims.
Right. And I'll just add to that also kind of goes for lawyers too. There are people who kind of have, right, the power differential, or this idea that lawyers are kind of up here and, they're down here. And so whatever the lawyer says goes, or, their opinion doesn't matter. And so just kind of being aware of that to kind of be able to break down some of those notions or those ideas. So let's talk about the first meeting, right? Now that we're in this world where Zoom is a regular occurrence, we're not only meeting our clients in person. And so each, whether you're meeting a client in person or on Zoom, like you kind of have to prepare somewhat differently. So in person, I know for us sometimes, things as simple as, do you know how to get here? Do you know what train to take? And just making sure that they, they have access to transportation, or they're able to get to you even reliably. What does your building look like? I know for our building, it's a maze to get into. And so we oftentimes meet our clients at the front desk because otherwise they would just be lost. And we also have security, which, sometimes that can be intimidating for young people. So just making sure, again, just to be clear about what's happening and do your best to facilitate the easiest kind of transition into the meeting as possible will go a long way. Also, I know when I was talking about lawyers and how there might have like a lofty idea of like what a lawyer is, you can break down or start to break down some of that by, even just letting your client choose their seat, or really kind of letting them take the lead from the beginning of the end of the first in-person meeting, right? Because if you come in and you're like, you sit there and I sit there, then that's going to continue to perpetuate this idea that like they don't have any agency in this process, and that they are not, a valuable part of this collaborative relationship. Often also, offer water and snacks. Like let's make them feel comfortable. Who doesn't love a good snack, right? So, start to kind of make them feel comfortable so that they will see you as somebody who is there on their side, who's there, who wants to help them, and not as another part of a system that they don't understand and that they're, oftentimes afraid of. On Zoom, I think there's a whole new kind of world of difficulties in trying to connect with your client, right? So now you're not in the same room. You have no idea what the room looks like, where they are, who's in the room with them. So, and also sometimes like maybe they might not even be at home. But definitely on your part, just doing everything that you can, to continue to create this kind of, I am here, I'm on your side, I'm here, I want to help you, waving, smiling, making sure that they are in a place where they can speak freely. I know that we can't always control that, but, we do our best to really kind of say, are you in a place where you can talk about some of these things? Oftentimes in these meetings, you're going to be talking about situations or events that have happened in their life that are extremely difficult for them to talk about, or maybe they haven't disclosed them to their caregiver here in the United States, whether that's a parent or another family member or anyone. And so really kind of before just jumping in, just kind of, having that small talk, and then also just making sure that they're in a place where they really can speak to you freely. And then fun backgrounds. I mean, if you can work Zoom, which I don't always think I can, it's fun, and it kind of eases things or eases attention and makes it less of this daunting meeting and something more that they feel comfortable kind of talking. And then, I talk about yourself, try to engage them in conversation. I know oftentimes like with some of our pro bonos who don't do a lot of work with clients, they don't do a lot of work with clients. They want to just get straight started, right? Like, okay, tell me about the abuse that you suffered at the hands of your mother, right? And I'm like, okay, let's take a step back. Like, let's talk to them. Let's, have some small talk, right? I think the next slide just talks more about that. Thank you. Well, yeah, so, something not law related. So, how's your weekend? Did you have a good weekend? Did you do anything fun? Have you watched any good movies? If they are obsessed with Encanto like we all are, then, definitely maybe bust out into like a verse of like, we don't talk about Bruno. But really just kind of getting them, to be comfortable talking with you. When I start meeting with clients and especially young people, really explaining confidentiality in a way that it's not so legal jargony. So I explained to them, I can't tell anyone anything that you tell me. And that includes like the president or like someone that's like really high up that they presumably think has a lot of power, like, the governor of your state, or, I can't tell anyone unless you give me the okay. They generally kind of giggle at that a little bit. And so it kind of starts to break the ice a little bit. Again, letting them know that this is a collaborative relationship and that it's not just what you say goes. So, you are a client and, what you want matters and this is your case. Oftentimes working with young people, this might be the first time in their life that they've ever had their voice even matter, right? So a lot of times they've probably been told you do this, you do that. And so giving them this opportunity to speak, to express their opinions, to really be part of this process is really invaluable. And then also just explaining that, like, you're not here, you're not a part of La Migra, like you're not a part of immigration, that everything, so feel free to tell me things and tell me the truth about everything, because oftentimes it's a lot easier for me to help you and explain things and be prepared when I know everything. So trying to kind of get them to ease up and understand that we are part of a team. So your first meeting should not be you know, I want to get the whole affidavit done. Like you don't want to, you're not going to get their full story. You might not even get to fully getting into the story. Sometimes I tell my pro bonos, let's just start with like getting to know each other and like talking about the process and what, you know, what we plan to do and what like maybe the first steps are. I sometimes don't even have them, you know, speak on any of the things that they've experienced. Sometimes giving them an assignment, like maybe go home if you like to write, maybe write it down, and then the next meeting come in and we can talk about it. So if, you know, first meeting, really kind of keep it simple and don't expect that you will have, you know, everything done in the first meeting. You know, and then I think it goes a long way to really kind of make yourself a person as opposed to just kind of this legal figure, right? So who are you? Like, what kinds of things do you like? Kind of make it sort of a share, give and take. If you want them to give you information about them and like some of the most traumatic events that have happened in their life, then it's only kind of fair that you share a little bit about you as a person. Not saying that you need to tell them any of your like most traumatic, you know, events in your life, but generally just kind of making it a relationship as opposed to kind of them speaking and giving everything and you just being there on the other end of that. And then, you know, you're the advocate here. And so really, I emphasize this so many times in our meetings that like, this is not just about what I want. This is about what you need, what's best for you and what you want. I ask lots of questions of them. I don't just tell them like, this is this. I ask them, okay, what is it that you want? How do you want to proceed in this? What are your goals? You know, what do you want for your future? Really kind of getting them engaged so that they feel part of the process and that they know that you're their advocate and that we're just here to help them develop the story, right? So I always explain to them, I don't know the story. The person who at the asylum office is really just gonna, you know, look at your file and listen to what you have to say. My job here is really I know the law, I know how the system works here, I know procedurally what to do. And so, you know, I can help you put together your story in a way that other people understand what you have gone through and why it's so important that you remain here in the United States and that you're not sent back to your home country. And then also thinking about how you dress when you meet with your client. We can't all be as dapper as this little fellow here, but also, you know, coming in very formal attire might actually be very intimidating to some of the young people. And so really trying to kind of dress down, you know, not like you're, you know, hanging out on the weekends, but really just, you know, business casual, I guess, or something that doesn't seem so intimidating to the young person.
And I'll just add there, like I'm wearing black right now. If I was meeting with a client over Zoom for the first time, I probably would have chosen a different outfit. I probably would choose something colorful. And, you know, because black can be kind of off-putting. You heard the young people in the video say that suits are intimidating. When they saw people in suits, it was basically because something bad was going to happen. And you might not have, if you work at a firm, you might not have any control over that. But, you know, I routinely wear blue jeans, and I think that's fine. You know, especially because it removes one barrier between you and your client. It might make them feel a little bit more comfortable. But I agree, if only we could all be as dapper as this pup. Oh, well.
Also encouraging them to ask questions. It's not just, again, like really kind of breaking down this idea that it's a one-sided, we are in control, asking them to ask questions and really making them feel that this is their case, this is their, this is their spotlight, this is their time to shine, so to speak, as far as, you know, being involved in this. So, you know, if they have any questions, I constantly ask them, anything you want to know, please let me know. If you don't understand something, or if you want me to explain something in a different way, or even just again, right? I always ask questions, or encouraging them to ask questions is good. again, not using legal jargon, really kind of the simplest language possible. You don't want this to seem like above their heads and that they're just kind of going to be like, okay, yes, like you really truly want them to understand what's going on and every step of the process. I try to like relate it to things that they might understand, whether culturally or just kind of as a kid or something related to television. I try to explain the visa bulletin as if you're at the deli counter, right? And so you take a ticket and your ticket is your priority date, and the like screen is the visa bulletin. You know, sometimes people in front of you are buying like 16 meats and like, you know, 10 cheeses, and other times, you know, it's like one thing really quick. We just never know when your number is going to come up. So I try to do things in ways that they understand, and things that they'll remember. Also making sure that like you are looking at them, right? I think that sometimes it's harder with Zoom because you can't really know like where people are looking. But I oftentimes have a second screen. And so I make a point of letting them know, if you see me looking this way, it's because there's another screen and I'm like reading something. Also, just I tell them that I'm going to be taking notes. I explain that I want to take notes so that I can remember everything that you're telling me. I am listening. Please know that. I just don't want you to have to repeat things. If I can take the notes, then it's going to be better. But I do try to not take notes like excessively. I like listen to them as they're speaking, and maybe sometimes when they take a break from speaking, I will then take notes, or try to just look at them as I'm typing. And then I'm going to pass it on to my colleague, Alex, to continue the rest of the presentation.
Thanks, Nicole. So this slide addresses issues of cultural humility and awareness, which sound like lofty concepts, but I want to just kind of emphasize how we can put those into practice, in our day-to-day lives as attorneys. And this also ties back to something that Nicole discussed, which is making connections with your clients. So this is something called an identity wheel. So maybe if you have worked on domestic violence cases, for example, you may have some knowledge of the power and control wheel, which is a tool that was developed to kind of understand gender-based and domestic violence. This is a more positive iteration of this concept of like wheels to understand ourselves and other people. So as you can see, it has a bunch of different blocks here: ethnicity, race, age, national origin, sexual orientation, gender. Maybe not at the first meeting. This might be a little aggressive for the first meeting, but like maybe at a second meeting, you could think about using something like this with your client. You could send it to, if you're doing this by Zoom, you could text it to them or use WhatsApp, really try to meet the youth where they are, or email it to them, whatever. If you're in person, you could just each have one printed page. And you could go through these questions. What identities here do you think about the most often? Which ones do you not think about that much? And you can use a different color for each. So you can have a kind of fun time doing some artwork as well. What identities are like the most powerful for you? And what identities do you when you see someone else and you think that they have that identity, what identity kind of impacts you the most? And you can just use this as a basis of conversation. It's not an assignment. It's not homework. It's just a kind of fun coloring project. And I like it because it goes both ways, right? You're learning something about the client, but the client is learning something about you. You don't have to do this. You definitely don't have to do something that's formal, but you could think about how to exchange information about your client's culture and identity and your own. So for example, like another thing that I might do is I wear a necklace and it has a bunch of charms on it, but one of them is a cannoli. It's a gold cannoli charm because my family is Italian and we love cannoli. And what can I say? So, if we were sharing something about ourselves, I might say, or like, what is something that means something to you that you have with you right now? Like, I would explain why this cannoli charm means something to me, and maybe the client would do the same for them. It's just a way to establish connection. There are a million ways to do something like this. So I'm giving you a few ideas, but you can kind of make that your own. And again, it doesn't have to be the first meeting, but you're kind of just trying to think of icebreakers where you will start to learn more about your client and eventually maybe start to learn more about the different types of claims that they may have for their legal case. Okay, so just moving on with interviewing, Nicole and I have been focusing on interviewing kids. I want to note that, Nicole and I both have experience also working with adults and working with families. So a lot of the stuff that applies for young people can apply for adults as well. Especially just the portion about making a connection and trying to ensure that your client trusts you. There's no reason for them to trust you at the outset. It's really your job as the advocate to help them get to a place where they feel like they can share things with you. But you shouldn't expect it to happen overnight, whether it's with a child or with an adult. So, especially with kids, I will say, if you ask a question and they don't answer right away, or they say something like, I don't know, or, they shrug, that's fine. But you can say something like, can you tell me more about that? And then just sit back and let there be some silence. And I know people are uncomfortable with silence. I'm uncomfortable with silence too. But sometimes as a way to fill that silence, your client may start to share something with you. So don't try to, in your own discomfort or anxiety, try to talk over the client or move too quickly. Give them some time. And related to that, make sure you build in breaks and that the clients know when those breaks will be, but they also know that they can ask for a break whenever they need it. So especially with traumatized individuals, it's a lot of mental work to go through the events that led to the trauma. It's extremely tiring. Your brain can feel wrung out at the end of it. So knowing that there's a break at 3:30, for water, snack, bathroom is really helpful. But then you can also say, whenever you need it, just tell me, and you can go step outside. When you're interviewing your client, I think it's important not to make assumptions. So if your client is talking and what they're saying triggers something for you in your own mind, wait a little bit. Don't try to fill in that information or plug the gaps until the client, actually shares more information with you, because you don't want to be in the situation of making an assumption that is offensive to them or simply not true. They may feel like they've disappointed you in some way. So try to just let the client do the talking, and you can certainly ask follow-up questions. Especially if the client is disclosing something like, my relationship with my parent was okay or not great. I would love, as an attorney, I need details about that. So you can ask follow-up questions. I would just say, take it slowly and gently. Using open questions rather than leading questions is a great way to get there. Instead of asking, as, for example, as someone who handles a lot of special immigrant juvenile status cases, which are based in abuse, abandonment, and neglect, a very direct question would be like, well, did your parent ever abuse you? Right? Because we want to see, are they ticking off these requirements for special immigrant juvenile status? But hearing, did your parent ever abuse you, is a bit aggressive. Asking a more open question, like, what was your relationship like with your parents? What do you mean by that? Sitting quietly, letting them talk. You're going to get to where you need to go at a more natural pace. A lot of times when I'm interviewing people, child or adult, I will, I'll ask a question and they might go on a tangent and I'll think, oh my goodness, okay, I hope they wrap this up because I have another interview that I have to do. And why are they talking about this other thing that has nothing to do with this? The fact of the matter is they may actually be giving you very important information. And so letting them talk in that way both builds trust and can help you develop a narrative that will ultimately be useful for their case. All of this is to say, just be a good listener. Do your best to listen to what your client is saying and also do your best to build in time. I know this is challenging, especially for those of us with large caseloads, but building in time so that your client, feels like they're really being heard is important. You may hear disturbing things from them. They may have experienced, they may have suffered some really horrific abuse. Be empathetic, but try not to recoil in horror or gasp. That can be very jarring. So do your best to remain calm and just keep moving on. It's always a good idea to have some idea about, especially with kids, try to do just a little bit of research. There's some really great basic articles about child development and kids up until I'm dealing with my own 4-year-old daughter who I'm like, does she know that she's pretending or does she think this is real? It's important to know around what age kids can start to have a concept of the difference between a truth and a lie or real life and pretend. And then likewise, younger kids tend to be a little more eager to please. So if you're asking leading questions, they might want to answer those questions in a way that they think you want them to. Whereas teenagers, we might expect them to be a little bit more reticent, a little quieter, and we need to think about how to draw answers out. Just be aware of people's body language. I wouldn't go to, don't go too psychoanalytic in this, but you can try to mirror body language. If they're sitting back, it might be a little abrupt for you to lean forward in their face, so just, you could do something called mirroring, not exactly, but that can, possibly help kind of establish a connection. And think about, when a break is needed, really just how to pause and stop. If you see the client is very upset, help them, they may be having a trauma response, help them take deep breaths in and out, remind them that they're to put their feet on the floor. You could tell them to put their hands on the table and say, can you feel the table? Can you feel your hands on the floor? You're here with me. Can you hear my voice? You're here with me. Take some deep breaths in and out. And hopefully in that way, they can start to come back into their body as opposed to, having the anxiety attack or the panic attack that they're experiencing. When you are preparing to take testimony in court, it is extremely important that your client know exactly what to expect. So we're going to walk into a door. And then I'm going to be with you and you and I are going to sit on a bench. And then I'm going to have to go up and speak to the judge's clerk at some point. And then I'm going to come back and sit with you. Then we're going to wait for your name to be called. I'm kind of running through a master calendar hearing. then you and I are both going to go up to the table that's on the right-hand side, and I'm going to sit next to you the whole time. This is what's going to happen. Do they have to raise their right hand? I remember when I was first representing young kids, it didn't occur to me to review with them that they would have to stand and raise their right hand and swear to tell the truth. And then they got confused about which was their right hand. And, like a judge scolded them, and I felt awful because I should have warned them, this is how this is going to go. And so now I do my best to always make a note, like, you're going to have to raise your right hand. So here it is. Here's what you have to say. When you're leading, when you're asking questions and soliciting testimony from your client, do your best to have other ways that you can ask the question. Because if your client gets confused, maybe it was an issue of interpretation, they didn't hear it properly, maybe they just got confused because they're overwhelmed. You can always ask questions in a different way. And that might lead them back to where they need to be. And then a kind of bleak recommendation is, if your client is emotional on the stand, make sure that the record reflects it. So I have paused, in taking testimony and said, Your Honor, I'd like the record to reflect that my client is crying right now. And that's important for probably obvious reasons, but like, if you have to appeal the matter to a higher court, you want those adjudicators to know that, they don't watch a video of this, of the proceeding. So you want the adjudicators to know exactly what was happening and how your client was feeling about it, because it goes to, for example, in asylum, it can go to credibility. It can go to whether what they suffered, actually counts as persecution. So there are a variety of reasons why you want that reflected in the record itself. And oops, that went too far. Okay. And at this point, I'd like to just talk very briefly about the ethical considerations when you're interviewing young people and people with diminished capacity. So in immigration court, there's overlap, of course, between very young people and people who have diminished capacity. And in most of the model rules, those populations overlap. So if you're working with, a young child, for example, the rules are for people with diminished capacity will also apply to young kids. I always, whenever I reread these rules, I chuckle a little bit because they're helpful, but they're not helpful, right? It's leaving kind of a gray space here. So this model rule, and it's in the first rule, it's in model rule 1.14, requires that attorneys representing clients with diminished capacity, including young kids or traumatized children, maintain a normal client relationship. Okay, like that's helpful, I guess. But let's think about what that actually means. What it means is the client is your client. The client is the one who directs the representation. The client is the boss. I tell my client, you're the boss, I'm your employee. So you have to tell me what you want to do, and then I'll help you do it if I can. So to the extent that you can maintain a normal lawyer-client relationship, that's what you do. You have to explain all of the steps in ways that might be different than if you were explaining it to an adult. But maybe you would do something like draw a decision tree, say, ask yes or no questions. If this, then that. There are ways that you can work with even your very young client to get the answers that you need. And an example, a really kind of harrowing example, is when Safe Passage was representing very young kids who had been separated from their parents at the border in 2018. we were, called into these detention facilities, and there we were working with tender age children, so very young kids, who didn't know where their parents were, because the Department of Homeland Security had, of course, separated them at the border. The parents had either been deported or the parent was in some kind of detention facility somewhere else, and we didn't know where. And we had to try to figure out what the client wanted. And usually if you're working with a very young client, there's going to be some adult, a caretaker, a guardian, a parent who can help you kind of advise and guide the child, even though the child is still the client. In those instances, we really had no one. It was the client on their own. And we had to kind of run through different scenarios with them. Do you want to reunite with your dad, even if it means moving back to Guatemala? And of course, I wouldn't use a word like reunite, because they might not know that word. I would use a word like, do you want to see your dad, even if it means going back to Guatemala? Or do you want to stay in the United States, even if you don't know when you'll see your dad again? Those kinds of questions. And they're extremely difficult to ask. And it's extremely difficult for a child to answer, but that is the role of the lawyer in that moment, to do your best to explain the options to even a very young child.
I will just, sorry, really quick, Alex.
Oh yeah, please.
Unless you're going to talk about it, but this also applies to like young people when their parents, or when we have screenings and we have young people and they're there with their parents, right? The parents automatically assume that they are going to be the person kind of directing the representation and telling us which way, what to do. But it's still really important that the parent and the child know that the child is the client and that the child is the person who ultimately will make decisions. And so while you can have communications with the parent, if the young person says it's okay, right, because they are the client, ultimately it's still important for you to meet separately with your client without their parent at some, at junctures, just to ensure that that what they want, how they want to proceed.
Yeah, absolutely. I mean, in instances where you're representing a family, it's extremely important for you to articulate who the client is. So if you're representing, a mom and she has a kid, is mom the client and kid is the derivative? Or are both of them clients? What happens if they have competing interests? What if one of them wants one thing and one of them wants another thing? That's where things get ethically even more tricky, which is why it's extremely important to make it clear to all parties who you're representing, who, as the attorney, who's the client. So establishing that at the outset is essential. The federal professional conduct, federal professional conduct for practitioners is the code of ethics specifically for immigration attorneys. It really does mirror the ABA model rules, which is good. In this case, we don't have competing sets of model rules. So for the FPCP, model rule 1.14 says, as far as reasonably possible, the attorney should consult with her child client and make every effort to understand and be guided by his or her wishes. And this model rule goes even farther and says a client with diminished capacity has the ability to understand, deliberate upon, and reach conclusions about the matter affecting their own well-being. So, and they even list some ages here where, you might consider a child as young as 5 or 6 can make decisions about their own life. So even though you might think that's extremely young, in fact, if you're the attorney and they're the client, the relevant rules indicate that you can and should be guided by their wants. And then just a note about confidentiality and privilege. So if it is necessary to assist in the representation, actually the presence of family members does not defeat attorney-client privilege or confidentiality. So when a parent or an adult is necessary to the representation, then it's okay for them to be in the room. And actually, this comment articulates that presence is acceptable. But you have to keep in mind, whose presence is necessary to assist in the representation and whose presence is, does the client kind of just want there. So I've certainly had situations where, a very young client wants their mother to stay in the room, and that's of course perfectly fine, versus a teenage client comes to a meeting with their significant other. I might, in that situation, I would let them know that I would explain what attorney-client privilege is and then ask the significant other to wait outside. I'm not going to go through this in too much depth. These are just some important follow-up questions that you might consider asking your client, kind of farther along in your representation, so that you get at all of the forms of legal relief that might be possible for them. I just wanted to mention one more thing. I meant to mention this in an earlier slide, but I forgot. If there is a situation where you are interviewing a family, right? With kids, again, having a parent or a guardian or just some adult caretaker in the room is often really helpful. You still may want to interview the child alone if they're okay with that. There may be things that the child client is not willing to disclose in the presence of family members. And the same goes for adults. If there is, a family-based claim and the mother, for example, was sexually harassed or assaulted, just as an example, she might not want her young children to hear about that. And so it's important at various stages in the representation to talk to each individual alone. Even if we don't represent, for example, the client's aunt or uncle, we have an 8-year-old client and they live with their aunt and uncle. Of course, the aunt and uncle are not our clients, and we make that very clear, but perhaps the aunt and uncle have some information that the young client does not, that would be helpful to the representation. And so in those instances, it's important to ask, all relevant family members for brief meetings alone with you, whether it's over Zoom or in person, just so that you can be sure that you're really mining all of the information that you can in support of the client's claim. Again, if they don't want to be separated, especially if it's a young kid, that's totally fine. You don't have to force that. And it's probably more important for them that they feel comfortable, but that can be a useful tool. Okay, so thank you all so much. I think we're coming up on the end. I just wanted to see if we have questions here.
We do. So one question was, how do you ensure adjudicators are trauma informed? Do you want to take that one? Do you want me to?
If you take that one, I'll take the one about the third party facilitation of the interview with the child.
Sure. So that's a very good question. And it's something that, we constantly struggle with. I think one way to do it is just remember you as the advocate. So in all documents and briefs or motions that we submit, we always, definitely add a piece about the trauma and how the trauma has affected the young person, whether it's their memory or whether it's their, just how it has affected their life. And then in an asylum interview, if you feel that the officer is not trauma informed or the officer is not taking those things into account, you as the advocate can, stop the interview and talk to the officer, or even ask for a supervisor if it feels like it kind of has escalated in a way that is not going to be beneficial to your client as far as like continuing the interview. In court, like Alex said, making the record is really important. So if your client starts to cry, if there are, noting things that might happen in court or things that you didn't find were handled appropriately for your client, for the trauma, definitely making the record so that, it can, when it goes up on the appeal, it's all there.
Yeah, I totally agree with Nicole. And there are a lot of, well, maybe not a lot and maybe not as forceful as we as advocates would like, but there is guidance for adjudicators on what it means to interview a kid, what constitutes persecution in the context of a child or a young adult. There's guidance from UNHCR on that. And so, it's important to be familiar with that and have it ready in case you do need to talk to a supervisor at the asylum office. I like this question. Do you ever recommend using a third party, like a social worker, to facilitate an interview with a child, especially a child who experienced trauma? Maybe. We try, so we're lucky at Safe Passage in that we do have a social work team, but their role is not to participate in interviews with the child. They do referrals for other resources. So it's really up to the attorneys to work with our clients and develop the affidavits and the stories. There may be a period in time though, when you realize, oh, my client is going to have trouble testifying before whatever adjudicator it is. And especially in asylum applications, it really is best practice to get a psychological evaluation or a medical evaluation. We rarely submit, well, Nicole, correct me if I'm wrong, but we rarely submit asylum affidavits without one or both of those things. So, in that instance, yes, you should absolutely retain a psychologist or a psychiatrist to evaluate the child. There are also times that working with the social worker is extremely helpful. And I'll give a super quick example because I know we're at time. We were in immigration court one time doing screenings when I got a message from one of the judges who was running a master calendar hearing. And she called me into the courtroom and she said, Ms. Rizzio, can you please interview this child? She took me aside and she said, Ms. Rizzio, can you please interview this child? Because she's here with her father, but he is being a little cagey and not answering the question about whether he's the child's father. And the judge was immediately concerned about trafficking. And so then I'm thinking, oh my goodness, what is the situation? So we took the child, aside. The family was very willing to have her be interviewed. I'm talking to her and she said, I'm starting to ask questions about her family. And she said she's feeling nauseous. And I'm starting to think oh no, there really is something wrong. She's having a trauma response. She goes to the bathroom, she throws up, she comes back. At that point, I call in one of our social workers and I said, I don't know what's going on here, but I'm kind of freaking out. Can you help me, please? And so we sat down with the young girl again. She was probably 8, 7. And we asked her to tell us more about her family. She drew a picture of her family, which included her dad and included, she had hearts all over it. It was really adorable. What we figured out after, and I interviewed the dad also, the issue was he was not her biological father, but she didn't know that. So the dad didn't want to say that in open court because he didn't, the young girl didn't know. So that's why he was being cagey about his role. The young girl threw up because she was new to the States and they went to Dunkin' Donuts in the morning and her dad bought her 3 donuts. And so she had too much sugar. And I tell that kind of convoluted but adorable story because luckily I had a social worker with me and we did art therapy basically and figured out what was going on, with the child drawing art and telling us about how she was feeling and then independently talking to the dad. So yes, we do use social workers or other third parties. in certain situations, but I think it's important for us as attorneys and advocates to be able to handle a lot of these interviews and meetings by ourselves.
Well, thank you so much to Nicole and Alex for that fantastic presentation. It was very informative and a lot of practical pointers and great examples for our audience. So we really appreciate you taking the time to share your expertise with us today. For our audience, we now want to turn to a segment on how you can get involved. Pro bono is a great way to use the skills that you've learned today during this training to practice your skills and to learn more about immigration. So Yasmin Yuvar, who is a senior staff attorney with the Children Immigration Law Academy, and myself, I'm pro bono counsel with the ABA Commission on Immigration. We're going to talk to you for a few minutes about how you can use the skills you learned today and get involved to give back to help a family or child. So Yasmin, why don't you take it away?
I will. And can you let me know, Stephanie, if you can see my screen okay?
I can see it, thanks.
Okay, awesome. So hi, everyone. Again, we're going to spend the next 20 minutes or so showing you how you can get involved now that you've learned a thing or two about representing children and families. And we host 2 platforms where you can basically view case cards describing pro bono opportunities and hopefully find one that's a good fit for you. And all of the folks that presented with us today are organizations that post cases on the platforms. So I want to talk a little bit about CELA's platform, which is actually called Pro Bono Matters for Children Facing Deportation. And then Stephanie's going to tell you a little bit more about the Commission on Immigration's platform. There are different opportunities posted on each, but the platforms actually work in a very similar fashion. They were created by the same folks at a place called Savvy Soup. So CELA's platform, like I said, is called Pro Bono Matters for Children Facing Deportation. And organizations basically post opportunities via something called case cards. The organizations are in states that are around the country, and sometimes they actually may be located in one state, but post an opportunity to work with a child who's in another state. The platform lives at various websites, including the CELA website. And if you go to our platform page, the top of your screen will basically look like what you see here on my slide. You don't need a password to view the case cards or otherwise utilize the platform. And organizations can post cases and take them down in real time. So the opportunities are always current. Our goal, of course, is to ensure that more children have representation, since it can make a huge difference in their experience during the immigration process and in the outcome of their case as well. Remember that children are entitled to representation, but at no cost to the government, so they have to obtain that representation on their own. Okay, here's the URL, and we'll also have obviously QR codes for you all, but this is where you can find the platform on our website. And okay, so just to kind of walk you through it, here's a sampling of some case cards. And if you just scroll down on that first page of our platform on our website, this is what you're going to see. Currently, I think there's about 60 opportunities posted, and you'll see that if you're interested in working with a specific organization, then you can actually use this partners dropdown and select one or more organizations. You could also type in an organization's name in the search function, and then you will get a filtered list of opportunities. And sorry, I know these might not be super easy to read, but there's one here that's for Latino Memphis. It's help a child obtain guardianship before turning 18. There's another special immigrant juvenile seeking adjustment of status that the Florence Project has posted. ProBar has one for representing children facing deportation in Pennsylvania. So there's lots of ways that you can use the search function to be able to find opportunities that best fit you. Sometimes case cards are going to be really specific and provide some factual details about the case, of course, with no confidential information. Sometimes they're going to be more general, where it's just a call for volunteers to help with a specific form of relief, for example. So it's really easy. If you see a case card that interests you, then all you do is you click on interested at the bottom of the case card, and it will prompt you to provide some basic information, your name, your email address, your phone number, your bar number, and then comments. And in the comments, you can use that to provide information like, I've never done an immigration case before, or I would love mentorship, or I can't do anything that involves hearings over the summer, but after that I'm free. So you can kind of provide some details to help make the best match possible. And what'll happen is the person at the posting organization, the designated person, they'll get an email with your information and they'll reach out to try to figure out if you're a good match for the opportunity. Sometimes when you get more details, you realize you're not, but that's okay, right? Because they may have other opportunities that you would be interested in or that would be a good fit, depending on your skills and your resources and just your time, your availability. You might also be interested in volunteering, but at a later date or when an opportunity better suits you. And you can actually use the search box to type in criteria and be notified via email each time a new opportunity that fits that criteria is posted. So maybe you want to volunteer with ProBar or only on asylum cases or only on cases that offer mentorship. You can actually also double up on criteria. So you could include ProBar asylum in the search function and then type in your email address. And every time ProBar posts a case that involves asylum as a form of relief, you'll be notified. So that's a great way to get opportunities later on, even if you don't see one right now. You can also share opportunities with colleagues or friends. Maybe somebody's mentioned to you that they're interested, or you know somebody who would be a good fit for a particular type of case. The platform makes that really easy. You just click on share at the bottom of the case card, and it'll give you a specific URL of only that case card. And you can send that around in emails, for example, which can be really helpful. So just another function that's really good to know about. One perk of taking a case through the platform is that you get a free hard copy of SELA's Pro Bono Guide. The guide is available digitally as well, but I love a hard copy to highlight and flag. I'm old-fashioned like that. The guide was originally released in August of 2020 and most recently updated in September of 2021. It's 101 pages and gives a lot of really important information about how to work with children in a way that's going to be effective. It provides nuts and bolts information regarding several forms of relief, like those that you heard about today, and what to expect in immigration court if your client's in removal proceedings, or what to expect at USCIS if your client has an interview. We give links so that you can learn more where you, as you go, and it's just a really nice resource if you want to do this work pro bono. If you take a case via the platform, the posting organization is going to let us know to send you a copy of the pro bono guide, but you can always reach out to us as well. Just again, the QR codes, so you can find SELA's platform. We also have a quarterly pro bono newsletter in which we highlight platform cases and just inform you of some helpful trainings and resources for the pro bono audience. And with that, I'm going to pass it on to Stephanie, who's going to tell you more about the Commission's platform and give you a live demo so you can see some of the features I just talked about, how they actually work.
Thank you, Yasmin, for passing it off. And I noticed that there's a question in the chat about malpractice insurance and whether that's covered. The answer is that it depends on the organization that you're volunteering with. Many organizations do provide malpractice insurance, but some aren't able to. So if you're taking a case off of the platform that Yasmin just showed you, that's a good question to ask in the comments section. So before you take a case, you can confirm whether malpractice insurance is offered or not. If you take a case through the ABA Commission on Immigration, we do provide malpractice insurance, but as Yasmin said, this platform really links you to organizations across the country, so we can't speak for all of them, so it's best to check in with the individual organization. Now, I want to share with you a little bit about the Commission on Immigration's platform, which, as Yasmin said, is very similar in functionality to the SELA platform that she just shared about. The main difference is that it's housed on the Commission on Immigration's website instead of SELA's website, and that it focuses on cases that are for representing families that are placed on the dedicated docket. And Yasmin, if you go to the next slide, I'll explain a little more about the dedicated docket. The dedicated docket is an expedited docket that was created in May of 2021 by the Departments of Justice and Homeland Security. And the dedicated docket is live in 11 cities across the country, and it places families on an expedited docket where the courts work to issue decisions in their cases within 300 days of the initial master calendar hearing. For those who have practiced immigration law before, you know that that is much faster than a normal non-detained hearing, which can take years. And the downside to this docket is that for many families, they're unable to find representation. They're unable to gather the evidence that they need and to get their cases together so that they can really access their full due process rights within the expedited time frame that their cases are being set for. So pro bono representation is absolutely crucial for these families so that they have a chance to really explain their case and to be able to find an attorney within the shortened time frame that their case is being heard. As of December of 2021, only 15% of families on the dedicated docket had representation, which is a very low number. So it's really crucial that these families have pro bono representation so that they are able to seek the assistance, the relief that they're entitled to. You can go to the next slide, Yasmin. These QR codes will take you to the platforms that Yasmin showed the slides, a step-by-step of how to walk you through it. I was going to do a live demonstration, but as Yasmin was talking, I realized that she covered everything so thoroughly that there's really not much to add by me doing it live. So thank you, Yasmin. That was you covered it all. And those slides that she put together will explain to you step-by-step what you need to do if you're interested in a case. One thing I want to encourage everyone is that if you are just curious, please go ahead and submit the interest form. It's just an interest form, and it will get you more information about any potential cases and the organization you might want to work with. You can also get information about mentorship, templates, documents that might be available to help you. So if you're kind of nervous about it and you're on the fence, go ahead and just submit that inquiry. It's not committing you to anything. It's just helping you get some more information about the case. And as Yasmin mentioned, on the platforms, the organizations that presented today, they have cases on the platforms. So through Safe Passage Project, through FERP, through Latino Memphis and ProBar, you can find cases. And as you can tell from our excellent panelists today, they provide great information and they're going to take good care of you as a pro bono attorney. So you can search specifically for those organizations. You can also search by city to find a location near you. There are, like I said, for the dedicated dockets, there are 11 cities nationwide where those families are located. And for the cases on Yasmin's platform for the children, they're nationwide as well. So you can search for something that's close to you, that's going to be the best fit for you, and go ahead and jump in and take a case. Next slide, please. And then the final point I'll quickly make is that the ABA Commission on Immigration does have a wide variety of pro bono opportunities. So if taking a case seems like it might be too much for you right now and you'd rather start by dipping a toe in with a virtual legal clinic or maybe providing some counsel and advice, providing interpretation services, you can go ahead and fill out our volunteer interest survey, which Emily has put in the chat, and we can provide you with more information about other volunteer opportunities that could be available or could be a good fit for you as well. Next slide.
I think it's me again. So we just wanted to flag for you all some resources that we have available. You have the support of the posting organization if you take a case, and you also have some resources available through CELA and the commission. CELA is a legal resource center, so we're a capacity building organization. We're here to support those doing this work. We create written resources and guides. We host webinars and trainings, and much of that information is available on our website, all of which you can watch for free. Our live trainings are also free. There's a wealth of information up on our website, including information about upcoming events, and I encourage you to check it out if you are in the field or if you take a pro bono case, because these materials can really help you work with kids and help you work in immigration law. And Stephanie, I know that COI has some great resources as well.
That's right. COI is in the process of finalizing a pro bono manual specifically for family groups that are on the dedicated docket. So that will be coming soon. We also offer a lot of free webinars that you can check out upcoming ones on our events page, and also follow us on LinkedIn. We post opportunities all the time to get involved, to join in free webinars or to find pro bono opportunities. And all of our prior trainings live on our Commission on Immigration YouTube channel, which you can follow as well. Subscribe to that, check out free trainings there. One point that I just want everyone to be aware of is that the immigration pro bono community, we really want your help, we need your help, and we're here to support you. So if you're nervous about it, a lot of people are. We work with a lot of people who have never litigated before, who've certainly never done immigration before, and your help makes a difference, even if you don't feel that you have the skills. There are people that will support you and provide you with the training and the skills that you need to be able to successfully advocate for someone, and having you show up in court with them is going to make all the difference for someone who's facing deportation. So we really encourage you to get involved, and even if you're nervous about it, just reach out if you have questions and we can talk you through anything that you might want to know.
Great. And I just wanted to highlight for you all that we've been plugging this Dropbox link that you all should hopefully have been able to access by now. It includes materials from today, including the presentation. So you have all the slides. It also includes additional handouts that we thought might be helpful to these particular areas. It includes the agenda, the speaker bios. It will include a mental health and behavioral toolkit that might be especially helpful for those of you that attended the last session. So definitely check out the link and access the materials. And lastly, I just wanted to say that the Dropbox links includes this handout, and we work to make it sort of as simple as possible for you to find cases or pro bono opportunities that might be a good fit for you. So it's a handout that's called How to Get Involved, and it has a state-by-state listing of organizations with a specific URL that gets you to case cards just for that organization. So it might be helpful to you to find pro bono opportunities if you know you want to do work in a specific state or with a specific organization. And I think that's all. So with that, I think we're right on time. I'm going to pass it over to my colleague, Laura Egan.
Fantastic. Thank you so very much. Just give me one moment to get up my screen. Okay, well, we've come to a close today for our training, our presentations. So thank you so much for being with us, for joining us. We also want to thank our wonderful panelists for sharing their time, their expertise, their experience with you. So thank you again to everyone who joined us for your interest, and thank you again to the panelists. We wanted to just recap and remind you, we hope that you are able to get involved. My colleagues just went over, the ways to do it. So please do visit CELA's platform and COI's platform. Go ahead and fill out that volunteer interest survey. We can get further connected. You can stay up to date regarding opportunities and resources. The handout, as Yasmin mentioned, has this information as well per state and per organization. And I know that a lot has happened today, and we've been putting information in the chat, but we do ask that you provide some feedback. We take feedback into heart, so please complete the feedback survey. That link again is in the chat. We also want you to know that CLE has been approved by the State Bar of Texas Committee on MCLE in the amount of 3 credit hours, of which 0.25 hours will apply to legal ethics or professional responsibility credits. So complete the CLE survey if you're interested in getting CLE credit. If you're in Texas and you tuned in and you completed that survey, then we will report your CLE to the State Bar of Texas. If you're licensed outside of Texas, still complete the survey, and we will provide you a letter of attendance to provide to your State Bar or accreditation agency. So thank you again for joining us, and that will close out our training for today. Again, some questions came up regarding whether the training is being recorded. It is being recorded, and we will be able to post this to CELA's website in the next 2 to 3 weeks, most likely. So take a look there and access the recordings if you'd like to see it again as a refresher or share it with a colleague. Thank you so much for joining us. Have a great day.